Okay, live stream's up and running. A couple more people to join here. Okay. So it's like we have everyone we need for at least the preliminary part of the hearing. Just curious, Attorney Martell, did you get the email I sent to the service list regarding witness appearances?
I did.
Okay.
I apologize for getting ahead of myself. I meant no disrespect by that, but yes, Glenn Barthels will be available if needed today.
Okay, I just didn't see him on the list. I wasn't sure. I'm going to make sure. Yeah, and I know it's a pretty unique process, and you're new to it, so no worries there. Just wanted to make sure we're on the same page. It actually is a question that comes up more often than I'd like it to, so probably just need some more clarification in the advance of the hearing. So. Okay, great. So let's do our preliminaries and we'll get on the record. So welcome to docket 9813 CE 100, the application for a CPCN of Silver Maple Solar. This is Michael Newmark, the administrative law judge for the PSC. We're connected on Zoom with parties and commission staff, as well as some members of the public. I think I have people that I have not identified as parties on the participant list. I'm assuming are members of the public here to observe. We're here to take evidence from parties and commission staff. We've taken public comments on Wednesday, live on Zoom, and we also are receiving written comments up until the end of the day today, like basically right before midnight, strike of midnight of today will be the deadline for filing comments online. And we also need to receive any comments by mail by today as well. So, hang on, another person here. So let's get our typical process over with here. I mentioned in the email to parties, we'll start with the service list and get appearances on the record. My service list is cooperating. So we'll just take that off the service list and start with Clean, Wisconsin.
Morning, Your Honor. Brett Cordy on behalf of Clean, Wisconsin.
Okay. Peniel Welsh Chapel Association.
Good morning. I am Carol Lee Schultz with Peniel Welsh Chapel Association.
All right. Public Service Commission.
Morning, Your Honor. Zachary Peters on behalf of the Public Service Commission.
Renew Wisconsin.
Good morning, Your Honor. Ori Walswick on behalf of Renew Wisconsin.
Okay. Silver Maple Solar.
Good morning, Your Honor. Delaney Brewer, Frederickson and Byron on behalf of Silver Maple Solar.
Town of Eldorado.
Morning, Your Honor. Luke Martell on behalf of the town of Eldorado.
Eldorado. I practiced Nekimi.
Yeah, you got it. Good.
I didn't practice Eldorado. Sorry about that. So yes, go ahead for Nekimi.
Luke Martell appearing on behalf of the town of Nekimi.
All right, great. So 50-50, that's a pretty good record. Oh, so before we change directions here. Any additions or corrections to the service list? No, okay, didn't think so. Did that one, okay. All right, so I'll go off the record at this point, and we'll see the offered evidence list, slightly different version than the ones that you were provided yesterday, because I noticed the omissions that I sent later on. So the first question's pretty specific. It's just if there are errors or omissions on the list. Did I miss any filings or get any filings wrong in terms of the PSC numbers or the names? So this is, irrespective of any motions or other matters we'll need to deal with in terms of receiving evidence. Just is the list correct as provided?
Later.
Anyone? Are you just looking at that, hoping you might have reviewed it beforehand?
Your Honor, scrolling, I just wanted to make sure the rest of our exhibits were on this version of the list. So with your additions yesterday in Wisconsin, looks good.
Okay. And yes, so there was also additions for the applicant, so the Sir Buttle.
Yes, Your Honor, that's what I was just looking at that as
Okay,
well. And
great.
I think they seem to all be there. If you've added
And-
the ones from your second list yesterday, they're all set.
And Nelson had one exhibit, is that right? I just want-
Mhm,
Yeah, okay.
yeah.
And yeah, so let's go down. Schultz didn't have any additional filings, nor did Renew. And Kaimai did not have anything new. Okay. Just let the next person in here. All right. Okay, so let's get on the record and we'll just say that we reviewed the offered evidence list and there are no corrections needed for the list, no errors or omissions. So this point, now what did I put in my email here? Let's go off the record for a second. I want to get this in the right order since I actually gave you the order last time. Okay. All right. Yeah. So off the record, we can deal with comments or questions in terms of the offered evidence list, the filing questions, anything.
Your Honor, do we need to do anything with the supplemental direct? Do we need to move that into the record or will that be treated the same as the initial direct for Larios?
Right. So yeah, that was, I mean, typically it's the motions to strike would be due before the next round of testimony. And to be honest with you, I don't know when that would have been for that filing, but I thought it came in between direct and rebuttal. Maybe not.
I believe it was filed right before Sir rebuttal.
Rebuttal. Okay. Well, I would assume that you would see right before Sir rebuttal. Well, okay. We haven't moved anything in yet. And so I can ask for objections before we do that, just to make sure. But I wasn't really anticipating there being an issue with that. I think we would have seen something in writing. Technically, I think we would have had something in writing come in at least before the hearing in order to consider it still at issue. So yeah, I mean, theoretically, it should be a motion should come before Sir rebuttal because that's the next round of testimony. If you can make an argument that it was too late to get a motion in by Sir rebuttal, there's certainly enough time to do so before the hearing, but we can button that all up when we get on the record. So
Okay, thank you.
any other questions on the comments? Just basically making references, things like that. I think there's some of the comments may kind of cross paths with the motion to strike in terms of the EA and how that's going to look. So I don't know if that's something we probably don't need to deal with right now, but okay, it sounds like everyone's good. All right. So now we can hear pending or authorized requests for an ALJ order. So by pending, I mean things that have already been filed. By authorized, things that could be filed, could be made during the hearing. For example, any objections to surrebuttal. Now would be the time to make those objections. So we did receive one such objection in writing, so we can take care of that. Will there be any other objections to testimony?
I was instructed that I could present a SOR rebuttal when I am asked to be a witness or my statement.
Right. That's
Okay.
a separate, that's
Okay,
separate.
thank you very
and
much.
We'll make sure you get your chance to do that. Sure.
Thank you very much.
Okay. So just for practical purposes, you don't really need to raise your hand to speak. If it's in terms of what if I'm asking people for something, you can just go ahead and tell me what your answer. So objections as well can be made just by stating the objection. Don't need to raise your hand. We just don't want to be talking over each other. So we're always pretty careful about that and do a good job kind of self-regulating. So let's get on the record then. And looks like we have one objection to testimony currently filed. There are no other objections to testimony. So let's handle the motion and then we'll move whatever documents we're going to move into the record after that. So yeah, we did receive the applicant's motion. It was no, that's not it. Huh, well, you know. It's on my screen somewhere, but I'm not going to rely on looking for it now. I think I have it here. Oh, there it is. So it's objection in motion. So it was titled Silver Maple Solar LLC's objection and motion to strike rebuttal testimony and exhibit of Andrew Kraft. I think technically we're really talking about the surrebuttal, and that's actually mentioned in the document. So
Yeah, I apologize for that, Your Honor. That's correct. It's the surrebuttal, the most recent round.
yeah, so there should be no confusion with that. Yep. So we do have the objection motion, so I can hear staff first and get their response.
Your Honor, is staff still entitled to the 3 days to formally respond to a motion per the facilitating matters order?
No, it's we hear those now live. So it's in lieu of a brief. We do oral argument. That's how it's presented in the facilitating matters order.
Your Honor, commission staff's position on this would be that the objections to Andrew Kraft's testimony and the contained exhibit, as well as statements made in the EA, are statements made in the regular course of action of Mr. Kraft's position with the Public Service Commission as the historical officer. It's been established and clear that the historical site or the potentially eligible for listing historical site in question, Peniel Welsh Chapel, meets potentially some eligibility as a listed NRHP historical site. And thus, under Wisconsin Statute 44.40, Mr. Kraft, as the historical officer at the PSC, contacted SHPO in order to get an evaluation per his regularly conducted duties at the Public Service Commission. He's not presenting such statements from SHPO as contained in the exhibit as the truth of the matter themselves. These are not sort of presented as additional testimony from a witness who is not present. It is simply the review is the request for a review, and then the subsequent sort of review of the review by Mr. Kraft is part of Mr. Kraft's duties as historical officer, and he is then taking his own evaluation of that review and presenting it to the commission as something that it can consider as sort of presented in his own words.
Okay. Okay, and that, does that cover then your arguments for both striking the testimony and also the environmental assessment?
Your Honor, the statements in the environmental assessment are, yes, it does. I mean, they are essentially the same statements. They are stated slightly differently between the EA and the testimony, but in terms of their effective meaning, they are the same.
Okay. All right. So before we get a response or reply from the movement, do we have any other interveners that wish to comment on this? No? Okay. All right. So any reply?
Yes, thank you, Your Honor. I think certainly we've laid out the initial argument in our motion, but I respectfully disagree that Mr. Kraft isn't presenting this email from the State Historic Preservation Office for the truth of the matter. The conditions in that email are exactly what Mr. Kraft is recommending and he's recommending it because of that email and the expertise or purported expertise of the author of that email. Which obviously we have not had an opportunity to cross-examine that author and test their expertise. Due process, requires that a party be allowed to test the value of this evidence for a proper foundation for speculation, reliance on statements of persons not present, and certainly for the level of expertise. And we can't test that rationale or legal basis of the information in that email because the State Historic Preservation Office hasn't provided a witness to do so, and because the commission staff has not laid a proper foundation for that document. So, Your Honor, Silver Maple Solar has offered expert testimony regarding this issue as well, and our expert is available today. So other parties can scrutinize her expertise, her experience, and her conclusions. Frankly, the applicant is not the only one who's raised concerns regarding the lack of information available regarding this communication back and forth. That's depicted in Craft Exhibit 1. Even the Peniel Welsh Chapel Association explained in their testimony that there's information that's missing from this analysis. So it's not uncommon to have two experts that disagree. In a case, I think it violates due process and fundamental fairness, frankly, to require only one side's witness to be present for the cross-examination. So that the burden of laying the proper foundation for this evidence is on the party offering it, and they simply haven't done that here.
Mm-hmm. Okay. Anything else from staff?
Yes, Your Honor. I mean, in this instance, we have Andrew Kraft available for cross-examination, available to provide foundation as to his position and his position's duties pursuant to Wisconsin Statute 4440, which include a mandate for a state agency to reach out to SHPO in the event of a potentially eligible impacted historical site. He's available to explain his processes by which he made his own evaluation and reached out to SHPO. He's available to explain his own conclusions as for recommending the condition as and is available for cross-examination on his decision to include that condition in his testimony. And further, the report itself is an informative report given to Andrew Kraft sort of in his position as historical officer at the Public Service Commission. And I would imagine it's akin to an expert reviewing a study that is then submitted into evidence in a record, in which case we don't require parties to or participants in a hearing to search out the authors of said study and bring them into the hearing itself. The expert who's relying on that study or report is allowed to then give their interpretation and how it's impacted their own testimony.
Okay. All right. Well, I did have a few questions, but probably need to pursue before I can rule on this. And I think the first one may be I'm sympathetic to the applicant, frankly, because I was just as surprised as probably they were to kind of reading the testimony to see how this issue was unfolding, and not really understanding where the time frames involved and how things were coming in, how things were getting presented to either side. Some of that's explained, and I think the surrebuttal Kraft's surrebuttal did help explain some of that, but I'm not so sure the proper procedure was pursued in terms of how that should have been presented on the record so far. But there also seems to be in between the lines in those filings it seems to me that when we're looking at fundamental fairness, which I sympathize with the applicant because of what I just said, when we look at fundamental fairness, it's really a matter of surprising the other side. I think the fundamental principle there is to avoid surprise, and it seemed like between the lines in the filings that there was back and forth between the applicant and staff regarding the issue of the registration and the status of the church in terms of the historical value, historical evaluation. So I don't know if attorneys can explain just in terms of the timing of what was going on, but it would be helpful to me to know when staff recognized the issue, when it reached out to the applicant about that issue, and it seemed to me in one of the filings that a response was still pending regarding the issue from staff to the applicant. I'm not sure if there's still a pending data request on this. So to me that's essential. It may not be the deciding factor, but I want to just make sure I understand how was the applicant informed about this issue. And I mean, obviously we have Nelson's testimony surrebutting, so there must have been some timing where the applicant knew what was going on and able to address the matter. The presentation of the exhibit Kraft 1, the statements in the EA, I think we need to deal with procedurally, depending on how this is all being ruled on. But I think, let me say first of all, I think it may be helpful that the EA is a staff document that's not necessarily something that I would regulate. It's staff's review of staff's presentation of its environmental review, for better or for worse. I don't know if I've ever seen a motion to strike the EA per se, but what can be done in the process of PSC 4, and I can display that on the screen. So there is an opportunity or an obligation that staff has to supplement the EA. So that may be a procedural way of curing any deficiencies in the current EA that ends up being part of this ruling, that a supplement can be filed. But in terms of striking the EA, I don't really think it's appropriate because it is a sort of a snapshot, a moment in time of what staff has done in its review. I don't think it's inaccurately portrayed what it's done so far in its review, but maybe the procedural problem here can be cured and then reflected in the supplement, So also just want to mention that because of our esteemed public participant yesterday who asked when is the deadline to make a decision in this case, I looked it up and I do have that available. So I usually don't pay too much attention because our process moves along pretty efficiently. But according to our extension letter, in this case, we have until March 18th, 2024 to issue our final decision in this case. So to the extent we need more process to deal with any fundamental fairness issues, I think there's time to address it. But I don't know who can answer this question best. We'll start with the applicant. If the applicant can provide any insights into the timing of when it received notice of the staff's concerns about the historical preservation issue about regarding the church, that would be useful.
Yeah, sure, Your Honor. The first we saw of, excuse me, the first we saw of any potential coordination with the State Historic Preservation Office was when it was posted on Earth, I believe a day before rebuttal testimony was due. So that would be the September 7th. That's really when we first saw this exhibit, but it was not entered into the record. And frankly, we were confused about whether and how it might be entered into the record. So in our rebuttal, partially because of the timeline of it being posted sort of just before the due date for the rebuttal, but also because of that confusion about whether, how this was going to play out, we did not address it in rebuttal. And so then the first thing on the record that we saw was the final EA, and the final EA has the language as we just talked about, the language regarding this recommendation, but that was not in the draft EA. So we didn't have an opportunity between the draft EA and the final EA to review and comment on that either. So really, the first time that then it of course was entered into the record with the SIR rebuttal. So that's why our response is now
Offered for the record. So let me just correct you just in a few ways. So that the terminology we would use is preliminary determination. That's what you're calling a draft EA. And then final EA, there really is no such thing in our nomenclature. It's just the EA. So just we're not confused about that.
Understood. Thank you.
So now I thought I read that staff did staff contact the applicant about the issue prior to filing or at any time before today in terms of getting more information or explaining its position on the situation?
I can jump in just briefly, Your Honor.
I'm asking the applicant.
I apologize.
Your Honor, I honestly don't recall this being the specific topic of a data request, but there were several. And so I actually may have to defer to staff if they recall a specific data request that addressed the historic nature. There was certainly a request about, the potential view from the chapel. But I don't believe there was anything in that request regarding listing status.
Okay, and besides a data request, any other communication?
Just a question posed to council for the commission regarding whether this would be entered into the record or not.
A question from you.
Yes.
Okay, got it. And did you get a response?
Yes, that it would likely be entered into the record.
And what was the timing of that?
It's a great question. It was, between September 7th and SIR rebuttal being filed. I apologize. I don't know the exact timing.
Okay. Yeah. Attorney Peters, do you have anything to add on that?
I would just add that I believe that there were a number of data requests regarding Penuel's Chapel. The first being about a month prior to, and here it's PSC reference number 474680.
Okay, let me get.
And that's about a month prior to the or filing of the SHPO email or response or evaluation.
Okay,
and that did-
just define SHPO for the record, please.
State Historical Preservation Office, something.
I think that's right.
That's
Yeah. Seems to match. And just give me that, so off the record, just give me that PSC reference number again.
474680. I believe that's the first data request
Let me get there.
that dealt with this particular site. And as council
Just
noted,
let me get there. We're off the record, so just, you know.
okay.
So. Okay, so I do have that here, but I don't know if we'll really need to reference it. Okay, so it's back on the record. Yeah, go ahead with any additional comment.
My comment would just be that this initial data request did deal with sort of the visual or other impacts, communications between the applicant and Penny, Penny Welsh, the party in this proceeding. And then following the SHPO communication that was filed on Earth, there were a number of other data requests regarding the recommendations made by SHPO and the applicant's position on those recommendations. And I can probably find those, but those I believe were filed right afterwards, sent out maybe September 13th or something along those lines. And I did want to note, Your Honor, that it may be helpful for everyone to table the decision on the motion to strike until Mr. Kraft testifies. I mean, he could certainly potentially provide the court with further information in order to help facilitate the court's decision on the motion to strike. And certainly, should the court decide to strike the requested portions of testimony in the exhibit, it could certainly also strike any testimony it found improper in coming to that decision as well.
Okay, thanks for the suggestion.
Yeah, I believe that the applicant, responded to data requests regarding the State Historical Preservation Office recommendations on September 27th. So that's PSC reference number, at least the first one, 480573. It's data request response. It's responding to Kitson-Bell 6.1.
Okay, yeah. And the next one, 6.2
is also, I believe, related. Yes.
That's correct. I think there was one for each of the proposed sort of conditions in the email.
Okay, so this is what we're okay. It clears things up a little bit. Okay, thanks for that. Okay.
Your Honor, I would just note that, really part of the issue here is when when responding to these data requests, the applicant wasn't sure whether what might be offered into the record, whether it would have additional information on what the State Historic Preservation Office reviewed in their analysis. We weren't sure what we'd see in their rebuttal. So obviously we responded to the best of our ability, but the sort of source of our objection at this point is that there hasn't been any additional analysis provided with that email.
Right. Yeah, I understand that. And that is concerning to me. I think what we can do though with that on that particular issue is to have witness Kraft available to explain that further. And that may be, we'll see how it goes, if that's enough. I would like to know, I know that Witness Craft did review the role of historical liaison, that he identified himself as a liaison. I can't recall to what degree he described that role and what the duties are. So, I'm just trying to see if we can sort of, amend the record to possibly answer some of those issues through the witness. That's not enough. We can take some other measures to see if we need to provide more foundation or more explanation. I think the Craft 1 as it stands, I'm not sure if I understand, just from a substantive point of view, what exactly the basis for those statements are. I mean, I know there may be a legal issue as to whether, and this was filed wrong, this has to be corrected, but there may be a legal issue that could be briefed about, what's the impact of these suggestions? Are they, is it legally tenable? Is it relevant? Well, is it practical? Does it have any practical effect on the decision here? I think it's useful for the commission to understand the existence of this situation, but I don't know to what effect these things have in the decision. And I think that would have to be fleshed out in either testimony or perhaps it's a legal issue. But I think it's fair to give Attorney Craft a crack at answering those questions. But I also wanted to, make sure we understand that as a staff, as a document that staff has in its records, it can avail itself of this document. So I'm leaning towards keeping these documents available for the commission, but I think we need to provide more information, both procedurally and substantively. And if Witness Craft is not able to answer the substantive questions, then we'll need to have some other process in order to bring that in. So I get all that. I think the fact that the applicant has already kind of has been made aware of the matter and has formed an opinion or a response about it through its expert is definitely a evidence in favor that the process has at least afforded the applicant the opportunity to respond. But I think the response, we want to make sure that we have all the evidence we need in order to make the correct decision or a reasonable decision on this. So let's have Craft address that on the stand, and then we'll see what we need to do at that point, if there needs to be further process. And like I said, we do have time. I believe there's time to take care of this in a subsequent process, however we determine that is. So I will take Attorney Peter's suggestion to table this until we get to the Craft testimony. But I think hopefully we have a fairly clear roadmap of where we're headed. Okay, so any questions about that?
Your Honor, just for the purpose of testimony and cross-examination, we should act then as if this exhibit remains in the record or is accepted into the record, correct?
Well, it's marked and offered. We won't receive it until we see what testimony we get from the witness, and whether you want to further press the motion further, or if I feel like we haven't gotten a clear picture of what the exhibit, especially what the exhibit is trying to express. So in terms of receiving documents, we can I think I know where you're going here. So if we're going to receive the documents in the offered evidence list, which is kind of our next step, I would not be receiving the craft testimony yet. But in terms of all the other documents presented on the offered evidence list, I believe there are no objections. So pending verification, they're all in the record. And I think our next matter is just to determine if we have crossed for witnesses, and we can excuse those that are not going to be crossed. So, so I guess let's just try that. I didn't think there was a lot of cross being anticipated. So are there any witnesses that, so, and let me just say, we can take your witness on the stand to verify documents and provide supplemental testimony, but in terms of cross-examination, if there are no questions, we can excuse that witness from the duty to appear. Party can still call its own witness if it wishes to. So just in terms of cross-examination, any cross remaining for the applicant witnesses?
Your Honor, this is Zachary Peters, Commission staff. I have a few questions for witness Nelson, just a couple.
Okay, and let's say we may want to keep Nelson in attendance for what's being said on the matter of the motion. So let's hold Nelson. We won't excuse witness Nelson until we're done. Unfortunately, you'll be here. Hopefully, it won't take too long to get to witness craft. Anyone else for the applicant? No. Okay. How about Clean Wisconsin? Okay, and then I'm talking about witness Mathewson there. Schultz, any questions for Schultz? And Vickerman? I didn't check the figures on your exhibit this time, so hopefully you're all adding up. How about Bartels? Any questions? Okay, Kraft and commission staff will call them to verify. Any staff witnesses that have timing issues now that we know of?
No, Your Honor, I intend to have all witnesses from staff side verify their testimony on the stand.
Okay, yeah, they'll just wait. Okay. All right. So at this point, for purposes of cross, all witnesses but Nelson and commission staff witnesses are excused. And we can call any witnesses from the applicant that we would like. So go ahead.
Thank you, Your Honor. Silver Maple Solar calls Andrew Schad.
Okay, see you there. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Good morning. Can you please state your full name?
Andrew Shad,
And where are you employed and in what capacity, Mr. Schad?
Westwood Professional Services as the Noise and Acoustics Team Lead.
Thank you. And have you prepared and caused to be filed in this proceeding direct testimony consisting of 6 pages and 1 exhibit?
Yes,
And if I asked you the questions set forth in your testimony today, would your answers be the same as set forth in your written testimony?
yes, they would be.
Right. Thank you. No more questions, Your Honor.
All right, and I'm assuming no cross. All right, thanks very much. You're excused.
Thank you.
Just moving on, Your Honor, the applicant calls Andrew Lines.
There you are. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Good morning. Can you please state your full name?
Andrew Lines, Lines.
And Mr. Lines, where are you employed and in what capacity?
I'm a principal with Cohn Resnick and I help lead our evaluation group.
Thank you. And have you prepared and caused to be filed in this proceeding direct testimony consisting of 5 pages?
I have.
And if I asked you the questions set forth in that testimony today, would your answers be the same as in the written testimony?
Yes.
Thank you. No more questions, Your Honor. Witness is available for cross.
Okay, any cross? No, you're excused, thanks.
Thank you.
The applicant calls Professor David Loomis.
All right, just unmute your device. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Good morning, Dr. Loomis. Can you state your full name?
David Glenn Loomis, Loomis.
Thank you. And where are you employed and in what capacity?
I am president of Strategic Economic Research LLC, consulting firm that I own.
And have you prepared and caused to be filed in this proceeding direct testimony consisting of 6 pages, rebuttal testimony consisting of 3 pages, and 1 exhibit?
Yes,
And if I asked you the questions set forth in your testimony today, would your answers be the same as set forth in your written testimony?
yes.
Thank you. No more questions, Your Honor.
Right, any cross? No, you're excused.
Thank you.
The applicant calls Mr. Joe Ridley.
Morning.
Good morning, raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Good morning, Mr. Ridley. Can you please state your full name?
Yes, Joseph Ridley, Ridley.
And where are you employed and in what capacity?
I am employed at Westwood Professional Services as a construction stormwater principal.
And have you prepared and caused to be filed in this proceeding rebuttal testimony consisting of 10 pages as well as 2 exhibits?
I have.
And if I asked you the questions set forth in your testimony today, would your answers be the same as set forth in your written testimony?
Yes, they would.
Thank you. And Your Honor, we have a few additional questions for Mr. Ridley in response to the pre-filed rebuttal.
All right, just off the record for a second. So I wasn't going to mention this, but since you're going to be speaking more, your microphone's a little choppy, so
Okay, apologies.
getting it a little
Is that bad?
closer.
It might be the rain.
Oh, it's actually the witness.
Oh, gotcha. Thank you.
You were good. You've been good. So
You might be too close to the microphone.
too close.
Okay.
I think. Okay.
Is that better?
Yeah, I think so. It was kind of cutting out a little bit, but we'll just play it by ear. Just be aware of that. So
Okay. Please let me know if you can't hear me.
all right. Okay, so go ahead. Oh, now you're muted. Delaney.
Apologies. Thank you. Mr. Ridley, have you reviewed the pre-filed rebuttal testimony of Dr. Mathewson, Cleveland, Wisconsin?
Yes, I have.
Are you familiar with the soil management and compaction minimization language in section 9.1 of the draft erosion control and stormwater management plan provided with the application?
I am. I am.
Can you summarize the intent of that section?
Yeah, the section addresses how areas are compacted during construction and will be managed after construction. Specifically explains that soil compaction will be avoided where feasible. And it also explains that areas that need to be compacted, like roads, pads, for equipment and inverters, will be further compacted as necessary to handle those components. And other areas that will be either revegetated or after construction returned to agricultural use will be decompacted and seeded. It also explains the timing and methods of decompaction.
Thank you. Does this language refer to decompaction only of the areas that will be deliberately compacted, like access roads and staging areas during construction?
No, this applies to any portion of the project area that's been impacted by construction.
Thank you. And have you been on site during construction of a solar facility?
Yes, yes. Prior to joining the Westwood team in 2021, I worked for a large EPC performing the day-to-day on-site environmental compliance for 11 years, specifically for large-scale solar and wind projects across the country. In the remaining 5 years with that EPC, I served as acting senior environmental manager. And I have had previous experience with similar projects in the region and in the same capacity of the ECSWMP, or referred to as the SWIP in other states, and manage those construction efforts from onset to notice of termination.
Okay, before you move on, just can you define or just explain the EPC acronym? Just give us
Yes, it's the Erosion Control Stormwater Management Plan.
Okay. They also said EPC, I think.
Oh, ECSWMP.
I think, Mr. Lee, I think Judge Newmark is referring to the EPC contractor.
Oh, I'm sorry. EPC is engineering, construction, and procurement. So it's the general contractor, engineering, and procurement of all necessary materials, equipment to perform construction.
Okay, so it's an ECP or
EPC.
PC. Okay, all right, that's fine. Thanks. Just want to make sure we're clear on that.
Okay, sorry about that.
Thank you. Mr. Ridley, when you're on site at these solar facilities, how did you or how do you identify where decompaction is needed?
Part of the responsibilities of the on-site environment manager is to track the equipment and understand the equipment scope and the work to be performed for that day. And then preparing the teams to install the appropriate BMPs to support that construction activity. And then to schedule the reclaim for that area within the timeframes outlined in the permit. And decompaction is relatively obvious based on a visual inspection, you know, where heavy equipment has performed the work, has traveled in and out of the work area. For tracked equipment like bulldozers, track loaders, and excavators, you'll see those impressions and tracks and rutting and soil disturbance and vegetation damage and matted down vegetation, things of that nature.
Thank you. And in your experience on these sites during these projects, after the construction process and decompaction has occurred, how do you know if the decompaction efforts undertaken were sufficient?
Well, it's fairly easy to determine. For example, you know, an excavator weighs 100,000 pounds or more. You will see where that piece of equipment was, you know, what it did, where it went. And if you don't decompact those areas and that disturbance, removing the ruts and depressions and matted down vegetation, et cetera, and reclaim those areas, stormwater, you know, we'll find these low depression points, these ruts, and we'll begin to focus water and erosion will occur. Depressed areas will pool water and hold water. So that makes it pretty easy to see. And, you know, it's a requirement in the Wisconsin permit and outlined in the ECSWMP to perform post-rain stormwater inspection and evaluation of the project area, specifically for that reason, to identify those areas that have may be holding or channeling water. And when performing decompaction in the soil, when the soil is compacted and pressed down, you know, there's a couple different techniques, but you know, ripping or tilling of the soil to break it up and loosen it up. And then as you do that, it fluffs it up as it becomes decompacted. And you perform this process until the decompaction, you know, and the ruts are removed and the soil will tend to sit a little bit higher than existing grade after you're done and you do it correctly. And you continue to perform that until you see those kind of results of the soil. You know, those areas will also, after you decompact, will require a mulch cover or some other type of erosion control measure. And, you know, as the installer, if you're having problems, you know, inserting staples, let's just say, into the erosion control blanket, or when you're anchoring the straw mulch and it's not compressing into that decompacted area, those are some indicators that, you know, the decompaction needs to be performed a little bit further.
So just to clarify, the identification of areas that have been compacted and the successful decompacting are easily identified. Would you say they're easily identified by an experienced environmental expert on the site?
Yes, yeah, easily identified by somebody that has experience with in that realm of reclamation.
Thank you.
Yep.
So the erosion control and stormwater management plan is marked as a draft in the application. When will the final version of that document be prepared?
The final version will be prepared after the design and layout is finalized.
And why will the applicant wait until that point to finalize that document?
You know, things can change, and each facility requires, you know, project-specific measures to address erosion and sediment control and stormwater management. While the generally applicable BMPs can be, you know, laid out early on in preliminary project design, a more detailed review of specific measures have to be implemented, you know, after, you know, they finalize roads and locations of permanent structures and exactly where the infrastructure will be placed to have a better understanding of the construction timing.
Thank you. In your professional opinion, and based on your professional experience, do you think soil density testing or other similar specific decompaction methods should be mandated by the commission for the Silver Maple Solar Project?
No, I do not. First of all, you know, there are tools readily available to ensure accountability, including, you know, enforcement under the DNR, general permit for controlling construction stormwater runoff. Second, it would be rather difficult to identify, you know, specifically what density requirements would be required for the project before final design. Density, soil conditions, soil types, you know, vary throughout the year and throughout the project site. And it's difficult to apply a uniform threshold across the project, especially a project the size of Silver Maple, and the scope for determining appropriate metrics, you know, for all those areas would vary significantly.
Thank you. I think that's it, Your Honor. Witness is available for cross.
Okay. Any questions? We'll start with our service list, beginning with Clean Wisconsin.
No questions, Your Honor. Thanks.
Okay. I don't have the list in front of me, so let me just going to scroll down here. The Chapel Association, any questions for the witness?
Yes, Your Honor.
Okay, go ahead. And you want to first introduce yourself to the witness and then go ahead with your question.
Hello, Mr. Ridley. I'm Carol Lee Schultz with the Penny Wells Chapel Association.
Morning.
Good morning. My first question is, how deep is the tillage?
How deep do you perform the decompaction?
Yes.
Well, that would vary depending on depth of topsoil, types of activities that would be performed for those areas. So it varies on multiple fronts there on how deep you actually rip and decompact those areas, case by case basis.
What would you say would be the deepest that you typically go?
Typically perform.
Yes.
Again, it depends on, region, location, results of the geotechnical report, depth of topsoil. But you would want to decompact primarily the topsoil layer that's been compacted through construction efforts without significantly getting into the subsoil layers, which could introduce some cross-contamination with some of those lower level fatty clays and soils, which could stunt vegetation growth. So it's a case by case basis. But general rule of thumb for solar is anywhere between 6 and 10 inches.
So if you do not try to decompact the subsoil, does that not interrupt the watershed?
I'm sorry.
The water, rainwater getting into the soils, into the subsoil. If the subsoil is not decompacted, it is very difficult for that water to get down to hold, that the lands cannot just hold the water in the topsoil. It has to go into the subsoil.
No, I understood. And it's inevitable that you will get into the top layers of that subsoil to introduce infiltration during the decompaction process. You just don't want to fully subsoil and introduce those level rasoils into the topsoil. So that's again why it's a case by case basis. You want to decompact to the level where you're introducing infiltration without incorporating some of the negative properties that some of those fatty clays and lower subsoils will do to the topsoil layer.
So when the project is done and all this is taken off, farmers will go in and do subsoil tillage to loosen up that subsoil as well without altering there's certain tools, certain implements used. And will these toxins at that point go into that soil?
So I'm not sure if we have a question. I'm not sure if we have a question that's proper for the witness, because I'm not sure what the witness's background on farming may be, farming practices. But if the witness has an opinion on how farming practices may how the project and reclamation may impact farming practices, and well, I guess to what extent, first of all, to what extent will the project area be farmed? That may be.
Your Honor, I'm not certain Mr. Ridley is the right witness to answer that question.
So I think a problem here I'm seeing is that we don't really know, or I don't think it's in the record that this area that was subject to compaction would be farmed necessarily. So if we need to establish that first before we know whether farmers would be tilling subsoil that was compacted. So I guess there just maybe not be proper foundation for that question.
Okay, thank you.
Yeah,
I knew it has to do with decompaction, so that's why I asked.
Yeah, I understand.
Thank you. That's all.
That's it. Okay. All right. Thanks.
Thank you.
Okay. Renew, any questions?
No questions, Your Honor.
The towns, I'll just put you guys together.
No questions, Your Honor.
Okay. And commission staff.
No questions.
All right. Okay. So any redirect?
Just one brief question, Your Honor. Mr. Ridley, when you mentioned cross-contamination between soil layers, were you just speaking to one layer mixing with another?
Yes, yes, I was speaking to the possible negative effects of achieving uniform vegetation if some of those subsoils that don't contain the organic properties needed for vegetation were incorporated into the topsoil.
Thank you. So to clarify, you were not referencing hazardous substances or some outside contaminant from outside the soil.
Yes, that is correct. Thanks for clarifying that, because I wasn't exactly sure.
No more questions, Your Honor.
All right. Okay, thanks very much. You're excused.
Thank you.
Your Honor, Silver Maple Solar calls Mr. David Kuhlman.
Okay.
What was the last name, David? Oh, I see it.
Kuhlman?
Oh, there you are. Yep. All right. Raise your right hand. You swear or affirm, tell the truth, the whole truth, and nothing but the truth.
I do.
All right. Go ahead.
Good morning. Can you please state your full name?
David Kuhlman.
Thank you. And where are you employed and in what capacity?
I'm employed at Westwood Professional Services as the wildlife manager.
And have you prepared and caused to be filed in this proceeding rebuttal testimony consisting of 10 pages as well as 2 exhibits?
Yes.
And if I asked you the questions set forth in your testimony today, would your answers be the same as set forth in your written testimony?
Yes.
Thank you. And Your Honor, we do have just a few additional questions for Mr. Kuhlman.
Go ahead.
Mr. Kuhlman, have you reviewed the rebuttal testimony of DNR witness Stacy Rowe?
Yes, I have.
Is Miss Rowe's recommended tree clearing avoidance period from April 1st to October 31st necessary to protect owls and raptors?
No, the recommended avoidance period is not necessary for this project for these species. While avoiding the removal of trees near or directly supporting any of these nests would provide additional protections, Westwood conducted stick nest surveys in 2022 to ensure avoidance of any known active raptor nests on site. And during these surveys, no stick nests were observed.
Thank you. And is Miss Rowe's recommended tree clearing avoidance period necessary to protect songbirds?
No, the recommended tree clearing avoidance period that extends from April 1st through October 31st is not necessary for the protection of nesting songbirds. Ms. Rowe notes that many songbirds will also nest later into August should their second nest fail. And while this is true, this doesn't justify the need for a tree clearing avoidance period that extends all the way through October. The recommended avoidance window extends beyond the period in which the vast majority of these migratory birds will nest, regardless of previous nest failures, as they need time to fledge and strengthen for their migration south. Secondly, in my experience, a strict tree clearing avoidance period from April 1st through October 31st is not standard practice.
Thank you. Is Ms. Rowe's recommended tree clearing avoidance period necessary to protect the northern long-eared bat?
No, the noted tree clearing avoidance period is not necessary for the protection of the northern long-eared bat. According to the Fish and Wildlife Service tree clearing guidance, non-federal projects are recommended to avoid tree clearing only during the pup rearing season, which is generally defined
I'm
as—
sorry, only during the, I didn't catch what she said. Only during the what season?
Only during the pup rearing season.
Thank you.
Yes. And this is defined as June 1st through July 31st, generally, to protect the bats during one of their most sensitive life stages. This remains relatively consistent with the WDNR's bat management guidance documents, which typically recommends avoiding the removal of suitable bat roost trees from June 1st through August 15th. Of further note, the Fish and Wildlife Service has recently acknowledged that unlike many of the other protected bat species, Areas of suitable habitat no longer require the assumed presence of this species unless documented occurrences are recorded nearby. So in other words, there's a substantial amount of suitable habitat for this species, and avoidance of all suitable habitat is not necessary to protect this population. And in these instances, the Fish and Wildlife Service notes that no avoidance period whatsoever is necessary to avoid risk of impacts. But really in all scenarios, the dates of April 1st through October 31st appear to exceed a reasonable avoidance period that will still minimize risk of impacts to the northern long-eared bat.
Thank you. Do you agree with Ms. Rowe that the avoidance period dates, again from April 1st to October 31st, that she recommends, quote, line up mostly well with the recommendations made within the migratory bird concentration site, end quote?
Not entirely. So I would note that recommended disturbance avoidance periods related to the migratory bird concentration site address migration periods only, and not the nesting periods within the summer months. So these dates appear to combine protections of birds during both migration and protection of birds during nesting, which creates an extended avoidance period that is much longer than needed and much longer than standard species-specific DNR recommendations. I would further note that if any tree clearing would occur during the spring and fall migratory periods, I would not anticipate significant impacts on migrating birds, as these areas are relatively isolated and therefore will provide limited foraging and nesting habitat. And really instead, there's higher quality, more intact forest resources in the immediate vicinity that would more likely support these migratory birds.
Thank you. Just a few more questions, Mr. Coleman. Have you reviewed the surrebuttal testimony of Dr. Mathewson?
Yes, I have.
So Dr. Mathewson notes that post-construction monitoring studies for avian species should be completed due to the fact that previous studies do not allow for, quote, universal conclusions, end quote, to be drawn. Do you agree with this assessment?
No, I don't. Before requiring studies that really amount to complex, expansive endeavors, I really think it's important to consider the scientific method. And research is driven first by observations. And while Dr. Mathewson does correctly note that few studies have been conducted, of the ones that have been conducted, none of them have yet to indicate that the lake effect hypothesis is a justifiable concern in this area. As specifically noted in the Badger Hollow report, quote, detections were found throughout the study period in relatively low numbers, end quote. As described in the application, though, Silver Maple will monitor for wildlife incidents and coordinate with local authorities if necessary. And it's my understanding that other projects like Silver Maple are similarly monitoring and recording wildlife incidents. This structure closely aligns with the observe phase of the scientific method and will help to inform the need for more detailed post-construction monitoring studies should the incidental wildlife observations indicate this.
Thank you. No further questions, Your Honor. The witness is available for cross.
Okay, so we'll start with Clean Wisconsin.
No questions, Your Honor.
Okay, the Chapel Association.
Yes, I have a couple. I'm not sure if Mr. Kuhlman is the person to answer the questions, but I'm, again, Carol Lee Schultz, the Pennywell Chapel Association. Does the Silver Maple Solar Project follow the Arbor Day Foundation recommendations of planting 2 trees for every 1 tree cut down? Or in your instance, Westwood?
So I would probably defer from answering that. That's not within kind of my realm of expertise.
Okay. Is that something your wildlife expertise would recommend?
once again, I think that I would withhold making any sort of recommendation, either for or against it at this point in time. That seems like something that is more associated with a vegetation management plan, of which I did not take part in.
Question that I'm hoping you could answer. If these trees or other habitats were planted earlier in the project construction mode, would that be beneficial to these birds and animals that would be displaced?
I guess I'm curious first if you'd be able to elaborate on what you mean by earlier in the project.
I have seen various construction projects where the landscaping, tree planting, the pond, creating ponds is the last thing on the list. And if there is land that's applicable for that in the project area, or if the project has plans to set this land aside, could that not be done earlier?
I can give you a general answer related to habitat diversity and the benefits of that, or proposed or possible benefits of that. And I do understand that Silver Maple Solar is proposing to plant vegetation that provides a diversity of habitat on the site. And it is the assumption that this diversity of habitat is beneficial for wildlife.
All right, thank you. That's all.
Okay. Renew Wisconsin,
No questions, Your Honor.
Towns,
No questions, Your Honor.
no. Commission staff.
Yeah, I just had a quick question.
Okay.
Mr. Coleman, this is Zachary Peters with the Public Service Commission. In your testimony just now, you mentioned that in your experience, tree clearing avoidance periods are not standard practice, or at least the one as recommended here is not standard practice. What do you mean when you say standard practice?
So I absolutely recognize that there are recommended tree clearing avoidance periods that we see. As I specifically noted with the Fish and Wildlife Service and with the Wisconsin DNR, they recommend a tree clearing period that extends from either June 1st through July 31st or June 1st through August 15th. What I have not seen in my experience has been a universal recommendation to avoid tree clearing that extends all the way from April 1st through October 31st.
Thank you. No further questions, Your Honor.
Yeah, I just want to go off the record before we excuse the witness, or before redirect, because there may be questions you want to redirect on. But I know that the witness mentioned, and I read it in testimony, on the concept that some of the requirements for these resources aren't triggered because the project isn't a federal project. And by federal, I'm assuming that means federally funded, or ones that needs to be federally permitted. But I'm not sure if that's in the record, what they mean by federal. And then I know I read in the record that at this time the project isn't federal, but that it could become one. And I don't know if does the applicant have an explanation as to when and how that would occur. And then I think what was meant was that according to this CPCN, it's not federal, and therefore the CPCN itself wouldn't have to deal with that issue, but that possibly in the future the project may become one that's federal. And then I'm wondering, well, is there a plan, or should there be something in the order that connects that transition to implementing the requirements? And this may be a legal thing, but if a witness is here that can explain and kind of define what these terms mean and how they apply or not, how they don't apply, that would be useful. And so I'm just going to ask you, Attorney Brewer, if you have any guidance on that.
Yes, Your Honor. Just to answer your question.
And we're off the record, but if you feel like we want to go on the record for that, we can. So, but we may need to be repeating some of this.
Yeah, that's fine. I think we can stay off the record, and you can sort of tell me what you think needs to be on the record. But I think that's correct, that it means it's not receiving any federal funding. If there's federal funding associated with the project, different federal requirements apply to the project. At this point, it's not anticipated that will be the case in the future, but never say never, I guess, is kind of the idea. If you would like us to sort of go through that on the stand, it might be Mr. Larios, who is the best witness to handle that.
Okay. Yeah, it might be useful. A few questions just to clarify the commission, because I think it comes up enough that the question's raised, but it doesn't sound like there's really any answer, and just to really just define what those things mean. I might have missed it, but I didn't see quite that specificity there. And then yeah, there was the issue of the idea that in the future it may become federal. And if you could clarify that whether or not you know of any possibility, that would be useful for the record.
Sure, we can certainly do that.
Okay, great. Okay, so then I guess there's no additional cross for the witness. So let's go back on the record. All right, so any redirect?
No, Your Honor, no redirect.
Okay, all right, well, thanks very much. You're excused.
Thank you.
Your Honor, the applicant calls Ms. Kelly Coots as the next witness.
All right. There you are. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. And your volume's a little low. I don't know if you can get your microphone closer, it might be useful.
Is that better?
Yeah, that is a little bit. Yeah.
Okay.
Good morning. Can you please state your full name?
Kelly Sue Kunst.
Thank you.
Kunst.
Thank you. And where are you employed and in what capacity?
I'm employed by Westwood Professional Services and I'm a senior permitting specialist.
Thank you. And have you prepared and caused to be filed in this proceeding direct testimony consisting of 18 pages, rebuttal
Yes.
testimony consisting of 5 pages, as well as 1 exhibit?
Yes, I have.
Thank you. And if I asked you the questions set forth in your testimony today, would your answers be the same as set forth in your written testimony?
Yes, they would.
Thank you. Your Honor, the witness is available for cross.
Okay, any questions? Chime in. Have any questions?
Hi, this is Zachary Peters, Your Honor. I may have one quick question that's best served here.
Okay.
Hi, Ms. Kunst, Zachary Peters, the Public Service Commission.
Hi.
There was a previous discussion and prior testimony given today regarding federal regulations being attached to potential projects, and that likely not being the case here. Would the requirement of federal permitting create a nexus by which federal regulations could come into play for this project?
Potentially, but I will defer to the attorney and Horatio to answer that.
Okay, that's fine, Your Honor. No further questions.
Okay, great. Any redirect?
No, Your Honor.
All right, you're excused. Thanks very much.
Your Honor, the applicant calls Miss Sarah Nelson.
Okay, let me undo that. All right, where are you? There you go. All right, I see you. Let's have your audio. No, I'm not hearing you. Maybe do you have a hard mute on your device?
Hi, I'm borrowing David Coolman's.
There we go. Okay,
video
so
service.
I'm gonna just change your names then.
I can do that quick if you want.
Oh, I'm almost there. So gotten pretty good at this. So it's
Sarah, S-A-R-A, Nelson.
okay, excellent. Great. All right, let me swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Thank you. Can you please state your full name, Ms. Nelson?
Sarah Nelson.
And where are you employed and in what capacity?
At Westwood Professional Services as an architectural historian.
And have you prepared and caused to be filed in this proceeding rebuttal testimony consisting of 6 pages as well as 1 exhibit?
Yes, I have.
And if I asked you the questions set forth in your testimony today, would your answers be the same as set forth in your written testimony?
Yes, they would.
Thank you. And Your Honor, we do have a few additional questions for Ms. Nelson.
Yes, go ahead.
Ms. Nelson, have you reviewed the rebuttal of Ms. Schultz on behalf of the Peniel Welsh Chapel Association?
Yes, I have.
In Ms. Schultz's rebuttal testimony, she describes the views of the project that she anticipates from the chapel. Does the information provided by Ms. Schultz change your opinion that the project will have no adverse effects on the Peniel Welsh Chapel?
No, it does not. Ms. Schultz describes the view shed from the chapel that may, in some cases, be more than a mile from the project, and facilities related to the project may be within the view shed of the chapel. But simply being viewable from the historic property is not enough to cause an adverse effect. Federal regulations laid out in the National Historic Preservation Act for the protection of historic resources states that although there may be views of the project, the introduction of visual effects alone is not enough to be considered an adverse effect. So as long as the views do not diminish the integrity of the property's significant historic features. And the view sheds, in my opinion, will not be obstructed by the project's relatively low profile, and views of the project will be minimized by the proposed vegetative screening. The vegetative screening is mitigating potential adverse effects for the views of the project, and that will aid in ensuring that the characteristics that convey any of the resources' significance will remain intact. So the views from the church are not integral to the chapel's historic significance and eligibility for the National Register, and therefore the views also will not detract from its significance or eligibility.
Thank you. Why aren't the views from the church integral to the chapel's historic significance or eligibility for listing? Excuse me, on the HP. Sorry, go ahead.
I'm sorry, I didn't hear the end of that. For listing.
For listing on the NRHP.
Yeah, so I recommended the Peniel Chapel eligible under criterion A for its associations with the Welsh community that settled in this area of Wisconsin in the mid-19th century. That criterion is considered an associative value, meaning that its significance stems from associations related to important events in the past and not necessarily because of its physical traits. I followed the guidance published by the National Park Service in their National Register Bulletin, how to apply the National Register criteria for evaluation. And that provides technical information on the NRHP from everything from surveys, evaluation, registration, and preservation of cultural resources. So I found that the chapel's area of significance is its associations to the wealth, ethnic heritage, and the settlement of this area of Wisconsin. The adjacent land use is simply not integral to the eligibility of the chapel, nor is its eligibility affected by the adjacent land use. In accordance with the guidance of the National Register Evaluation Bulletin, the chapel physically represents the period of the congregation's significance, and the views of the solar project's installation will not affect the chapel's ability to continue to convey that significance.
Thank you. Have you reviewed the pre-filed rebuttal testimony of PSC witness Andrew Kraft?
Yes, I have.
And on page 3, Mr. Kraft explains that that information provided by Silver Maple Solar is inconsistent with the testimony submitted by the Peniel Welsh Chapel with respect to the project's impacts on the chapel's, quote, physical aspects of integrity, end quote. Do you agree that this is inconsistent?
No, I don't. Ms. Schultz describes her perspective of project's potential impacts on views from the chapel, and as acknowledged in the application and in my previous testimony, panels may be visible from the chapel, but that has no impact on the chapel's physical aspect of integrity. The chapel, although Ms. Schultz may disagree with my professional opinion, there are no inconsistencies between the underlying facts in my architectural historic survey report and those in Ms. Schultz's testimony.
Thank you. In your professional experience, is it, and I'm quoting here from Mr. Kraft's testimony, is it, quote, common historic preservation industry mitigation practice, end quote, to require a developer proposing to place facilities on property near a historic property that's potentially eligible for listing, like we have here? Is it that common historic preservation industry mitigation practice for the developer to provide resources for the property's NRHP listing?
No, it's not common practice to require a developer to provide those resources for National Register listing based on low impact use of adjacent property. It may be appropriate where there are more severe adverse effects to that historic resource, and in cases where other forms of mitigation are not appropriate. However, in this case, the adverse effects can be physically minimized with vegetative screening. And the example identified in Mr. Kraft's testimony or rebuttal testimony relates to an entirely different scenario.
Can you explain that a little? Can you explain the difference between the example that Mr. Kraft provides and in his pre-filed rebuttal and the Silver Maple Solar project?
Sure. In the case cited by Mr. Kraft, the project would result in the complete demolition of the historic property in question. In a negotiated memorandum of agreement between the applicant and SHPO, the applicant agreed to install and maintain a historical marker near the demolition site. Here, for Silver Maple, we're talking about an indirect visual effect to the historic property. The proposed project is a relatively low-profile facility in agricultural fields in distant views from the chapel, with the closest facility screened from view by the proposed vegetation. This potential indirect impact is not really comparable to the demolition of a historic resource. Because the project will have a relatively minimal impact compared to the cited case, the visual effects will be minimized by vegetative screening. And providing the resources for a National Register nomination is a much larger and complex expense than merely a historical marker, especially when the adverse effects are minimal compared to total demolition.
Thank you. Just one additional question. Mr. Kraft states that in some circumstances, a historic property can be affected by a project to the degree that it will no longer be eligible for NRHP. Do you believe that the Silver Maple Solar project may affect the Peniel Welsh Chapel to a degree that it will no longer be eligible for NRHP listing?
No, I do not. It is not common for land use on adjacent properties to indirectly affect a historic resource to the extent that its eligibility could be lost. Specifically with respect to the Silver Maple project, the adjacent land use does not currently contribute to the chapel's significance or eligibility, and a change in use on nearby land would not affect its ability to continue to convey its historic significance. The potential impacts of this project are indirect and will not be of the type or magnitude that could affect the church's eligibility.
Thank you, Ms. Nelson. I have no further questions. I think the witness is available for cross.
Okay, we'll start with our list with Clean Wisconsin.
No questions, Your Honor.
All right. And I think our next up is the Chapel Association. But to be honest with you, I don't know why I put the Chapel Association section, but you are. So that was just, I guess it is alphabetical. Yeah, there you go. Huh. Okay. I was thinking there were some other parties here, but okay, yeah. So Chapel Association, you're next.
Yes, I have some questions for Ms. Nelson. Hello, I'm Carol Lee Schultz of Penny Wells Chapel Association. And thank you for your study. And I am very glad that you had the opportunity to come out to see Penny Wells Chapel.
Me too.
And are you from Minnesota? I know your company is, correct?
Yes, I grew up in the Twin Cities, and with Westwood, I have gotten to do a lot of renewable projects in throughout Wisconsin and a lot of rural areas in the Midwest.
Sure. So you've probably seen other rural churches like Peniel. There are quite a few. Okay, thank you. But you did not, looking at your report, you said you had like a windshield view, so you did not get out of your car. Is that correct?
For the initial phase of the survey, it was mostly just recognizing historic resources during the windshield survey and then revisiting significant and previously recorded resources during the reconnaissance survey. So in those cases, for the Peniel Church, I did get out of the car and viewed the church from several different angles. And because I didn't have interior access, I wasn't able to conduct as thorough of an eligibility recommendation as is usually required for such projects.
Is that common when you are sent to do an evaluation that you do not contact the owners and try to get inside, see the church interior?
It depends on the project, but typically, no, it's especially because most of the visual effects are outside of the project area itself. Getting landowner permission for accessing land and things like that is not a step that's typically taken for reconnaissance architectural history surveys.
Okay. Yes, we would have been very happy to unlock the door for you and get you in if you wanted to do that.
It's good to know. I appreciate your Facebook page and all of the photos on your website too that you've shared, both recent and historic as well.
Sure. Well, thank you. So the only purpose you have for this evaluation was to find out if we are eligible for national, I shouldn't say the only purpose. See if you thought we might be eligible for National Registry, but also on behalf of Silver Maples, correct?
Yes, as a professionally qualified architectural historian, I followed the survey guidance in the manual published by the Wisconsin Historical Society. So followed those regulations and guidelines throughout the course of the survey. And any property that I identified as having potential eligibility or was already listed on the National Register, I consider the project's potential effects for those.
And this thing that you did see our Facebook page and all, but you cannot make any comments on how this project would affect our events or our mission. Is that correct?
I don't believe that it would physically affect the church property, and the indirect visual effects that the project would cause are not necessarily associated with specific events at the church.
Okay.
The chapel will be able to continue to convey its historic significance and historic traits in spite or despite of the project.
Okay. Thank you very much. That's all.
Thank you.
Okay, we'll continue on with it's renew.
No
Questions?
questions, Your Honor.
No. The towns
No questions, Your Honor.
and commission staff.
Well, yes, Your Honor, just a couple.
Sure.
Hi, Ms. Nelson, Zachary Peters with the Public Service Commission of Wisconsin. I just had a couple quick questions. You make clear in your rebuttal that Peniel Welsh Chapel is potentially eligible for NRHP listing, but you appear to contend that further evaluation of eligibility is not warranted in this case. Is that correct?
For the purposes of this report, a formal determination of eligibility, which SHPO or the National Park Service makes that determination, it wasn't required because I treated it as if it was eligible or listed and considered the project's effects on the potentially eligible resource just like I would if it was already listed in the National Register. So to pursue a National Register nomination, there would need to be more research. It couldn't just be done with what I presented in this report.
Is it your contention, understanding that SHPO would be the entity making that, eventual determination, that
Yes.
such determination is not warranted or necessary in this case?
If they, I guess, can you rephrase that question?
Yeah. So your report's evaluation determination was that this site is potentially eligible for NRHP listing, but that an entity such as SHPO would be the entity that makes that final determination.
Yes.
Is it true then in your rebuttal that you appear to indicate in saying that such evaluation from SHPO is unwarranted, that you are contending that further evaluation as to eligibility is not necessary or warranted here?
No, I don't agree with that's my contention. I believe that it's not warranted to get a formal determination of eligibility because I already treated it and I considered the effects for it, which I would do if it had already been determined eligible or was already listed in the National Register. So it would be, it wouldn't change my findings if it was determined eligible by SHPO. I would still say that there were no adverse visual effects.
Okay, thank you. And then one final question. With regards to these determinations as to eligibility of NRHP listing, when is the appropriate time in sort of a project such as this's timeline for a potentially impacted site to move forward with a more formal determination from an entity like SHPO?
That would be at the discretion of the commission, I believe, or the owners themselves could pursue request from SHPO to provide a formal determination.
Is it your contention that a formal determination of eligibility, official eligibility for listing, would not change the plans for this project moving forward?
Correct. The visual effects are minimal and the proposed vegetative screening would minimize that even further. So the physical mitigation of adding that screening, I would recommend in this, and if it was already listed, determined eligible or potentially eligible.
Okay, thank you. No further questions, Your Honor.
Great. I just had a few clarifying questions for the witness. My screen will behave. Yeah, just curious in terms of timing of the different studies that your firm had filed. So the cultural resources desktop review is part of, getting this right, Appendix W of the application. And it's dated January 30th of this year and filed February 24th of this year. And I'm just looking through the page here and it says, it was essentially conducted the desktop review on March 26, 2021, and then updated in October 2022. So all that's still correct, right, as filed? Okay, and then...
in words, please, if you could answer.
Oh, yeah, sorry.
Yes, those dates are accurate.
Okay, and then the agricultural history survey report, the top page. So that was dated February 10th, 2023, filed on the 24th of that year. And well, if I think it was, I don't necessarily have a date that I noticed here, but I think my main question is essentially what prompted the applicant and your firm, Westwood, to move from having the cultural resources desktop review and then kind of step up into the architectural survey. What prompted that decision to go with additional study? Is that well, let me just see what your answer is for that.
It's typical in Wisconsin for similar solar and renewable projects to conduct a reconnaissance historic survey, especially in rural areas. A lot of properties were initially inventoried in the mid-70s and have not been updated. So we're getting buildings that might not have even been built yet falling within now historic status for their age, and conditions change. So it's good to update known resources and identify previously unrecorded resources.
And is that standard practice for CPC on applications?
I will defer to Delaney and Horatio for that, but I believe so.
Okay. And I guess you may have mentioned this in testimony. Do you have a date when the architectural survey was conducted?
March 2022. I know the actual dates are in the report somewhere.
Expect it to be, yeah. So there is sort of an overlap then between the initial desktop review and the update to the literature review update was October 2022, and in the meantime the architectural review was conducted.
Yes, and although there were changes to the project area that necessitated the literature review to be updated, those changes all fell within the original survey area and area of potential indirect effects for the architectural survey. So additional survey was not warranted for those changes.
Okay. And then, so in the survey, so it seems to me like the relevant difference between regarding the chapel, between the cultural resources review and the survey is that the designation for the review in the cultural review was that there was no indication of eligibility, or was unknown. I think I have it here.
At the time of the literature review, it had not been formally evaluated.
Okay, I just want to get the correct language here because it said, was it simply unevaluated?
Yes, and that's reflective of the data that came straight from the Wisconsin Historical Society's preservation database that contains those inventory forms.
Okay. And then in the architectural survey, that recommendation changed to potentially eligible for NRHP.
Yep,
And that's your recommendation.
correct.
Okay. And then so that was simply your own study. It wasn't initiated. What I'm trying to say is that the looking at the church was not initiated by an outside source. It's just par for the course in doing a architectural survey.
Correct. Any historic age structure or object resource would be inventoried during the survey, as long as it was within that area of potential effect.
Okay. And then one other question, I was just looking at your extensive resume, and I noticed a number of projects. I was just curious, in your experience, have you recommended that a project as proposed change its footprint or its changed what's being applied for based on an impact to an historical structure?
I don't think anything ever resulted in needing to change project layouts for it. Either in cases like the Bennington Wind project, there were already issues of integrity concerns, so those conditions were just perpetuated, and it wasn't a problem for the project to continue. And for others, there has been adequate vegetative screening or distance between project layout and resources so that they were not adversely affected.
Okay, so your recommendation was that no change to the proposals were required?
Correct.
Okay. All right, that's it, and thanks. So any redirect?
Just a few questions, Your Honor. Ms. Nelson, Attorney Peters asked you, excuse me, about the timing of pursuing formal listing as it relates to the CPCN process. Would you agree that whether or when a property pursues formal listing is irrelevant to the CPCN process?
I do agree with that.
And is that because your studies and your review takes a more conservative approach in that it assumes eligibility when eligibility may not actually be an option?
Yes.
And the ALJ asked about amending project design based on some of your findings. Do you, while you're performing your studies and preparing your studies, performing your analysis and preparing your studies, is it fair to say you maintain contact with the applicant during that process?
Yes.
The applicant being Silver Maple Solar in this instance?
Yes.
And if you were to come across a historic property and the proposed project layout with respect to that historic property was a concern, would you make that recommendation to the applicant prior to the final report?
Yes.
And so
go ahead.
So it's fair to say that you would informally sort of alert the applicant that this may be a concern and they should consider perhaps amending their design.
Yes, so that the project can continue to flow through the process and they're aware of potential roadblocks as soon as possible.
So it's fair to say that those project design adjustments would in fact be made in many instances before the layout was actually proposed in a CPCN.
Correct. And that is sort of reflected in the dates and changes to the desktop literature review as well.
Great.
In our report.
Thank you. No further questions, Your Honor.
Okay, great. All right, thanks. You're excused.
Thank you.
And you may want to stay though.
Sure, I will.
Yes, I'm not going to excuse you completely, but yeah, I just forgot about that. So we'll have testimony from witness Kraft. You may want to be online for.
Yep, sounds good. Thank you.
Okay, great. Okay.
Your Honor, the applicant calls Mr. Horacio Larios.
All right. See you there. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
All right. Go ahead.
Can you please state your full name?
Yes, good morning, everyone. My name is Horacio Arturo Larios.
Thank you. And where are you employed and in what capacity?
Nope, you're muted somehow. You don't appear to be, but I'm not hearing you. It's those batteries probably. Nope, still no audio. Well, this may not be such a bad time to just take a brief recess if you want to. Yeah, we can adjust the equipment here. So let's just take a break let's make it 15. We'll get back in 15 minutes. You can stay connected here. Don't go anywhere, but we'll just be off the record till 12:15.
Thank you.
Yeah.
How about now, Your Honor? Can you hear me?
Oh, there you go. You should have waited. Yeah, well, we're gonna break now until 12:15. So you could just sit tight for now, but yeah, we'll reconvene at 12:15 and take you as a witness.
Thank you, sir. Appreciate it.
All right.
Apologies for the inconvenience.
right, well, it's about 12:15. We're just getting back on.
Wouldn't be out of the question to do a mic check, sir.
Absolutely
Can you hear
not.
me?
I can hear you loud and clear.
Thank you, sir.
And just waiting for staff to join us. And we have Chapel. Okay. And there's a town still out. I guess we're only about a minute out, but I think we want to get started here. Okay. All right. So I believe I need to swear you in. So raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth.
Yes, I do.
Great. Thanks. Okay, go ahead.
Good afternoon, Mr. Larios. Could you state your full name?
Horacio Arturo Larios.
Thank you. And where are you employed and in what capacity?
I am a director of development at Leeward Renewable Energy, an independent power producer. Silver Maple Solar is a wholly owned subsidiary of Leeward Renewable Energy.
Thank you. Have you prepared and caused to be filed in this proceeding direct testimony consisting of 31 pages, supplemental direct testimony consisting of 2 pages, rebuttal testimony consisting of 19 pages, surrebuttal testimony consisting of 6 pages, as well as 4 exhibits?
Yes, I have.
And if I asked you the questions set forth in your testimony today, would your answers be the same as provided in your written testimony?
Yes.
Thank you. And we do have a few additional questions, Your Honor.
Sure, go ahead.
Mr. Larios, we spoke a little earlier about the ALJ raised some questions about federal funding of the project. Can you explain whether the project will receive any federal funding?
Yes, in some instances, federal funding for a project may implicate additional environmental requirements. It is not anticipated that Silver Maple Solar will seek federal funding that would trigger those requirements.
Okay, thank you. Have you reviewed the surrebuttal testimony of Mr. Wu?
Yes, I have.
So assuming nameplate capacity is defined as proposed by Mr. Wu in his surrebuttal testimony, can you specify the intended nameplate capacity of the Silver Maple Solar project?
Yes, I can. Mr. Wu suggests defining nameplate capacity as the nominal generating capacity based on the total megawatts DC rating of the panels and the DC to AC ratio of the inverters used. There is a range of panel options and potential inverters under consideration, and the DC to AC ratio may change depending not only on the equipment selected, but
okay,
also—
I'm just gonna interrupt for a second. Can you just slow down, please?
Yes, sir.
Okay, thanks. Go ahead.
The DC to AC ratio may change depending not only on the equipment selected, but also on other factors such as the uniformity of the power blocks in the final design. Ultimately, these numbers can't be determined with certainty until final design. However, based on the options being considered for the project, the maximum nameplate capacity of the project as defined by Mr. Wu, and not considering any potential losses in the system, would be 224 megawatts AC.
So do you agree with modifying Mr. Wu's proposed order point regarding the project's capacity? This is provided on page 6 of his direct testimony, to specify a capacity of no greater than 224 megawatts AC.
Yes, Silver Maple Solar agrees with Mr. Wu's proposed order point if it is modified to include a capacity of no greater than 224 megawatts AC, understanding that the designed generating capacity is slightly higher than the 200 megawatt AC capacity of the project at the point of interconnection in order to account for losses in the collection system. However, the maximum output of the project will be 200 megawatts AC at the point of interconnection.
Thank you. Have you reviewed the rebuttal testimony of Ms. Schultz on behalf of the Peniel Welsh Chapel Association?
Yes, I have.
Ms. Schultz states on page 4 of her rebuttal that the association has not received a description of what vegetation might be used for screening near the chapel. Can you describe the vegetation screening that you've proposed for the chapel?
Yes, I can. Silver Maple Solar has proposed a landscape buffer that includes a combination of large and small evergreen trees, deciduous trees, and deciduous shrubs. The proposed buffer plan includes species of varying height and width, with mature size ranges from approximately 5 feet to 80 feet tall. A preliminary list of species that will be considered for the screening plan and their specific dimensions were provided in the response to data request 6.1.
Ms. Valerios, why hasn't Silver Maple Solar entered into a written agreement with the chapel for vegetative screening?
There are a few reasons for this. First, it is difficult to determine where the vegetative screening will be located prior to final project design. Attempting to reach an agreement on a vegetative buffer design would be premature at this point. More importantly, the Chapel Association has not demonstrated a willingness to discuss a vegetative buffer because they do not believe any type of vegetative buffer will address their concerns, as Ms. Schultz has stated repeatedly.
On page 7 of her rebuttal testimony, Ms. Schultz poses several questions regarding the community meeting on May 23rd, 2022. Can you provide additional details regarding this meeting?
Yes, I can. The meeting was announced via postcard. It was held at the American Legion at 500 Fond du Lac Avenue, Fond du Lac, Wisconsin at 6 p.m. According to the signing sheet included in Appendix T of the CPCN application, at least 28 people attended the meeting. However, not all attendees signed in, so there were more than 28 attendees.
Did Ms. Schultz attend the May 23rd, 2022 meeting?
Yes, she did. The signing sheet indicates that Ms. Schultz attended the May 23rd, 2022 meeting.
Ms. Schultz also mentions an invitation to Silver Maple Solar for an interview on a local radio morning news show on page 7 of her rebuttal. Are you aware of that invitation for an interview?
Yes, Silver Maple Solar has been in contact with the WOSH morning news program and is working on finalizing a date for the interview.
Have you reviewed the rebuttal testimony of Dr. Matthews?
Yes, I have.
Dr. Matthews suggests that if mowing is required during the months of April through October, prior to vegetation being fully established, that Silver Maple Solar should have trained personnel survey that area in advance of the mowing to reduce potential wildlife impacts. Do you agree with this suggestion?
Yes, Silver Maple Solar will survey prior to mowing during those months, both before and after vegetation is established.
Your Honor, no more questions. I think the witness is available for cross. We'll finish.
Okay, thank you. So I just wanted to mention, I don't know if we've established this yet, but our normal practice and how it's indicated in the facilitating matters order is that the data request responses will be offered for the record in staff exhibit. So the data request responses that we're referring to will be received for the record based on that standing practice. So I think there may have been some confusion before as to what was being offered, potentially if some of this information was in the record or not, but but data request responses will go in as part of the record under the as offered by staff in that exhibit. So that was a long explanation, but anyway, let's have Cross. We can start with our first intervener, Clean Wisconsin.
No cross, Your Honor.
Cross, okay. The Chapel Association.
Yes, Your Honor, I'd like to cross.
Okay, go ahead.
Hello, Mr. Larios. And
Good afternoon.
Good afternoon. Carol Lee Schultz with Penny Walsh Chapel Association. I just have some general questions about constructions, but also some questions that were presented by our association. And I want to reiterate that when they mentioned Ms. Schultz, I would like everyone to know that this is the association and my name is just attached to the comments and our documents.
Yes, that's understood.
Thank you. So the main question I get from the association is who owns Leeward Energy?
Leeward Energy is owned by OMERS, the Ontario Municipal Employee Retirement System, which is an entity which manages retirement funds of teachers, firefighters, and police officers of Ontario.
Okay, thank you. Okay, some general questions about the project. Is the Silver Maple project considered to be low impact as described in Exhibit CW Mathewson?
Which number exhibit?
481445, sorry.
Oh, okay, you're using the, okay, so I'll go off the record for this. So you're using the reference number. Do you have the number of the exhibit as we marked it? So it's like
no, I do not. I'm
okay.
sorry.
Your Honor, I believe it's 22.
22. Okay, thanks.
Thank you.
Could you, I'm sorry, still,
yeah.
Could somebody help me with the PSC reference? I think I'll be able to find it a little bit quicker that way.
Okay, yes, it's 481445.
Thank you.
And this is a, oh, okay, they redacted hyperlinks. Yep. So your question, is there a page that you'd like to direct the witness to according to that statement you're talking about?
Well, I guess right there is a good page. What is low impact solar development?
And, I see. So generally speaking, okay, great.
Generally speaking, so I'm wondering if that is the same for this project.
Okay, so before we get back on the record, do you understand the question, witness Larios?
I'd like to maybe request clarification.
Okay, so if you could restate that question, Ms. Schultz, for us, and let's get on the record for that.
So I'm assuming there are different types of development in solar. And this one that I'm referring to is low impact. And that has a lot to do with how the is cleared and the type of machinery that is on the land and things like that. And being that it is farmland, I'm curious to know if it is low impact solar development that would be more beneficial to reclaiming the farmland.
Yes, ma'am. I can speak to the merits of the project as stated in the application, as well as the erosion control and stormwater management plan. The project will commence by establishing best management practices as recorded in the erosion control and stormwater management plan. These best management practices include first the removal of topsoil, the storage and covering of topsoil, so that
I'm going to interrupt. I'm sorry. I to the extent you're going to review what's already in the record, we probably don't need to go over that. And I appreciate your willingness to answer, but I think maybe we'd be best served with time if we could go through the list that's on this exhibit and just tell us if you in your opinion the project meets those requirements in terms of the defined the descriptions that are listed as low impact site preparation. We can go through this list and just tell us if you, in your opinion, you believe the project meets that standard. That may just be a easy way to be more direct to the question. So let's just go through that. And so there's the top. So this is exhibit Mathewson 22, and there's a question posed by the exhibit: what is low impact solar development? And it compares conventional site preparation to what's called low impact site preparation. And you can see that on the screen share. I don't know if you have that in front of you, witness Larios.
I do, sir. I can see the slide. Thank you very much.
Okay, great. So we just go through that what's being presented here. So in terms of clearing and grubbing of soil and roots, in terms of conventional site preparation, the low impact version of that is existing vegetation is left intact or is replaced with low growing native vegetation species or crops. So I guess the question is does the proposed project plan meet the low impact site preparation criteria for that particular item?
Yes, it does.
Okay. And if you wouldn't mind just going down through the list and just answering one way or another for each one. So for example, topsoil stripping. Yeah. I just want to go
topsoil stripping and stockpiling, the spirit and the intent is met. As I described, topsoil is initially removed, stockpiled, protected, and then it is reapplied. So yes.
Okay.
Land grading and leveling, utilizing.
But in terms of let's just stick in terms of the exhibit. I'm sorry, I just want to be exact with this because we have the document in front of us. So in terms of the topsoil stripping and stockpiling, so the low impact version is existing topsoil is left in place to allow for the successful growth.
I'm sorry, Judge, I lost.
Okay, sorry.
No, you're
Oh, am I cutting out? Oh. How is that any better? I'll just stay closer. No, you are frozen, Debbie. Yeah,
Your Honor, I don't believe that it's you, actually. I think it might be.
I see that now. Okay. Well, we'll allow her to rejoin us.
You cut out for me. I'm not sure why, but
yeah, you are. Oh, that was that. Maybe she'll. Yeah, there she goes. There you go. You're back. So you're cutting in and out. Did you see that?
Yeah, it said it lost.
Mm-hmm.
Okay. You want to just go ahead, or you want me to try and call in? You can just.
Well, yeah. Let's try it and see.
Okay.
Yeah. Could have been a glitch. Okay.
So I lost you in terms of the.
Okay. All right. So we're gonna answer the questions just by going through the specific language of the exhibit and just give us your best guess or yes or no or a more elaborate answer is fine. But I just want to make sure we're addressing what's being presented in the exhibit. So we did clearing and grubbing of soil and roots. And now the next one was topsoil stripping and stockpiling. And the low impact version is existing topsoil is left in place to allow for the successful growth of native vegetation and to promote soil health post decommissioning of the solar project. So how does the proposed project fit into that criteria?
That criteria is met with the caveat that, as explained in the application, existing topsoil will first be removed during construction, will be stored, protected, and will be reapplied after construction.
Okay, so land grading and leveling utilizing heavy machinery, that's the conventional site preparation, and the low impact version is natural contours of land are worked into the design and configuration of the solar project with minimal, if any, land grading required.
Natural contours will be worked into the design and configuration of the solar project. And I believe that our project application, our preliminary grading plan would agree with minimal land grading.
Okay. Soil compaction utilizing heavy machinery on the conventional side. On the low impact side, soil and vegetation are left intact to facilitate the growth of native vegetation, improve stormwater management through less runoff and erosion, and soil health.
There will absolutely be improved stormwater management through less runoff and erosion and soil health. Soil and vegetation will be disturbed as already stated in the application.
Okay. Conventional side, land footprint for the foundations of vertical support structures, often including concrete.
I'm sorry, sir. Can I go back to the last question?
Oh.
With regards to the growth of native vegetation, native seed mixes and vegetation will be planted throughout the site, so that that intent is also met.
Ah, okay. Okay, I see. All right. So land footprint, conventional version of that is land footprint for the foundations of vertical support structures, often including concrete. Low impact side, lower land footprint for foundations of vertical support structures, often driven piles.
This lower land footprint of foundations is also met by the project.
Conventional vegetation that supports habitat is discouraged and removed. Low impact vegetation that supports habitat. And then, for example, pollinator species, other native fauna is encouraged.
This goal is also met by the project.
Okay. So in terms of fauna, any clarification for that?
Yes, there will be pollinator species that also get planted, and the fences will have an 8-inch gap from the bottom to the top in order to allow for small mammals to cross through. The project will also be setting back from waterways and wetlands, and so that means that the fences will not impact the crossing of fauna through those project features, of which there are many.
Great. Okay. And conventional side O&M activities include herbicide spraying, mowing of weeds and other vegetation, and low impact, minimal O&M activities due to low growing native vegetation species could involve livestock grazing.
Minimal O&M activities due to low grading native vegetation species will be met. We are in the early stages in the company of evaluating agrivoltaics and perhaps sheep grazing.
Okay, and you said agrivoltaics, is that correct?
Correct, sir.
Okay. Okay. Just curious, in terms of the low growing native vegetation, any investigation or possibility of using edible species, like for instance, like farming blueberries, strawberries, that kind of?
So the vegetation management plan does describe low growing native vegetation species, and as I said, sir, we are in the very early stages of evaluating agrivoltaics, which would be the raising of some of those edible fruits.
Okay, so it includes
those edible vegetation.
Okay, great. Okay, so I think that covers the question, Ms. Schultz. Is that?
I have a couple comments. In the second note about the topsoil stripping and stockpiling, I totally disagree with his answer because.
Okay, well, you can address that when you take the stand.
Okay.
As a response to what he says.
Okay.
But if you have a follow-up question to clarify in your mind what the witness's comment was, you can go ahead and ask that.
Sure. Okay. When you're talking about the vertical supports, how are those supports held into the ground? And how deep?
There will be a detailed geotechnical investigation. Currently, we have conducted a preliminary geotechnical investigation, which informs the perceived depth of the steel-driven piles. I believe the depth is somewhere in the 4 to 8 foot range.
And what is the substance that holds the support in the ground, other than just the topsoil and subsoil?
The geotechnical investigation informs the engineering properties of the soil in terms of the piles being able to stay in place. And so these will be steel piles which will be supported by the engineering properties of the soil.
So there will not be any added concrete or gravel?
It is not expected at this point. The additional geotechnical investigations could identify areas which have rocks or other geotechnical features which may require the need to pre-drive some piles and then install them. To pre-drill into the soil or the rock, and then the piles get installed in those pre-drillings.
Okay. My next question, which is based on the same exhibit, is which speaks about the alternative land use sites or alternative solar sites. Has the Leeward Energy used alternative sites such as previous land use that is not typical for, not capable for farmland anywhere, such as contaminated soils or something like that, that cannot be farmed any longer? Has Leeward Energy done any solar projects on those sites?
Okay, so off the record for a minute, what page are you referencing on this exhibit, just so we have a reference point with your question?
Sorry, I do not know.
Okay, so it's alternate sites is the kind of the key word here.
Right. I think it's closer to the end.
Seeing that phrasing here. Well, okay, so I mean, I guess there's no dispute that's in the document somewhere. Let's see. Okay, site selection.
And while you're looking at that, if I could just add another alternative would be like rooftops and parking lots.
Yeah, let's not get too far ahead, but okay, so let's just have the first question read back. I think I may have just disrupted this too much. So the court reporter is going to read it back for us.
My next question, which is based on the same exhibit, is it speaks about the alternative land use site or alternative solar sites. Has Leeward Energy used alternative sites such as previous land use that is not typical or not capable for farmland anywhere, such as contaminated soils or something like that that cannot be farmed any longer? Has Leeward done any solar projects on those sites?
Okay, so if you could answer that question, please.
To my knowledge, I'm not aware if we have or have not. We have many projects that we are looking at. I can say that I have definitely looked at trying to do projects in alternative sites such as landfills and coal mines. So all of those alternative sites are constantly in our mind for evaluation.
Just not underground coal mines, right?
Correct, sir.
That's just trying to lighten things up here. Okay. All right, go ahead, Ms. Schultz. Did you have a follow-up for that?
Yes, and in your opinion as an engineer, are these sites comparable in producing the same amount of megawatts over the same area that will be covered by arrays?
That is a difficult question to answer because of the variable nature of technology, environment, subsoils, weather.
Another question that was brought up to me is the glare study. And just a quick yes or no question, has anyone addressed the glare effect to the nearby airport in Oshkosh, specifically regarding the Experimental Aeronautics Association fly-in or EAA annual event? Because the planes that are coming in, landing every 2 minutes, there's a plane landing, and the flight pattern follows through the town of Nekimi. So has there been a glare study done?
Okay, let him answer the question. It's fair.
Yes, I believe that we've carried out a study which took a look at airports in the vicinity that could potentially be affected. And the study determined that no adverse effect to those airports is expected.
Okay, thank you. How many months do you anticipate the construction of the Silver Maple project?
The Silver Maple project will take approximately 12 to 24 months. It is difficult to tell at this point the exact number of months, given that it'll depend on the engineering, procurement, and contractors, construction means and methods, their available equipment, their available manpower. And so these projects are very uniform. They are very similar in construction activities throughout the site. So the final schedule will be determined based on equipment, resources, efficiency, and other design factors.
And you feel that this time period will not have any effects upon Penny Welsh Chapel activities?
As stated in my testimony, that is correct, ma'am.
One question I had asked previously was deferred was, will this buffer zone that you are proposing for Penny Welsh Chapel, will that be established in the early stages of the construction project, or is that the end stage?
Can you please elaborate on what you mean by buffer zone, ma'am?
Or I'm sorry, the screening. I'm sorry, I stated that incorrectly. The screening.
So I'm going to put on the screen. I'm sorry. I just put on the screen the data request response to PSCW-AC-6.1, which includes a diagram that I believe is what we're going to be referring to, at least in theory. It's the response that demonstrates some of the vegetative screening that the applicant is proposing. At least that's what I'm assuming it says. So I just want to make sure I got that correct. If you could verify that, witness Larios.
Could you please restate your question, Mr.
Yeah,
Jones?
what am I? Oh, just can you answer? This is what we're talking about, the vegetative screening. That's the document on the screen.
So at what point of the construction project?
Okay, I'm sorry, I'm not being clear. Can the witness just verify that we're looking at the right document?
Yes. Oh, I'm sorry.
The witness.
You were asking Mr. Larios that.
Okay, I'm sorry, sir. I'm sorry, Your Honor. I didn't understand who you were referring to.
That's
It's much
okay.
more clear now. Correct. This is response to data request 6.1. This is the proposed vegetative buffering plan.
Okay, for the chapel. Yeah, okay.
Correct. Yes, sir.
Okay, so now we're looking at the plan, and I believe we had a question then. So, or we're getting to a question. So go ahead, Ms. Schultz.
The question is, at what point during construction would this screening be planted?
This screening, I believe, gets planted near the end of construction.
We will potentially, or we will be seeing this construction going on, and we won't have any screening for that time, correct?
Correct.
Okay. I guess pertaining now to, was there a historical review done with Bethesda Church?
I believe it was, yes, ma'am.
I have not seen that statement anywhere. So now I'd like to refer to your meeting with us at Penny Welsh Chapel. And it was July 28th, 2023. And do you remember what was all discussed at that meeting? General.
Yes, ma'am. We discussed who my company was, what the benefits of solar projects were, what some of the potential adverse effects were, and we also discussed the history of why is it that I am doing solar development projects, and I use my experience in previous technologies, mostly fossil fuel technologies, that ultimately arrived at my entrance into the renewable energy, given that I believe that we need to transition into clean energy rather than me using my expertise in fossil fuel combustion.
Okay, thank you. Have you stated in your report that we did speak about history of the Oshkosh Welsh settlement and Penny Welsh Chapel?
I don't recall specifically if I said that, but we did discuss history, ma'am.
Yes, we did. And you did state there were more people there than myself, and that again was not in the report. Did you take any photos or measurements that day?
No, ma'am, I did not.
And I don't believe you said in your report, where else did you go that day after you left Penny Welsh Chapel?
We went to your other church, ma'am. However, I'd like to go back, and I'd want to say that I have taken pictures from the right of way of your church as well.
Okay, thank you.
Your Honor, may I just ask for clarification here on which report Ms. Schultz is referring to?
Okay, yeah, that's a good question. So let's go off the record and, well, let's stay on the record, actually. Let's just get a clarification from you, Ms. Schultz, which report we're referring to.
Oh, this would be my pile of papers here.
Uh-huh.
Sorry, I'm so inept because I've never done this before.
I understand.
I believe it is in the third rebuttal.
Uh-huh.
Rachel.
Okay, I had a feeling, yes. So we're just crossing.
I'm sorry. I'm sorry. I have the papers, but I don't have time to read through them. It may be in the first initial rebuttal.
Okay, rebuttal. Okay. But you're referring to testimony when you said report.
Okay.
Previously, you were referring to the witness's testimony. Is that true?
I think I have it. I believe it's the rebuttal testimony of Horatio Lario.
Okay. And is there a page that we should be looking at or an area with testimony?
He already stated on page 12, he already stated that he did discuss the screening vegetative buffer, he called it.
Mm-hmm.
I am sorry, I'm not finding it. Okay, he met with us. No, that's, well, on the 12th, or on the July 28th, so that is on page 12.
Yes, okay, I see that. Okay, good. So that's,
Did you
and
need
that's,
the document number?
no, that's fine. We're with you. I just wanted to make sure that when you were asking the witness questions about the report, what you called the report.
Oh, I'm sorry.
Well, just let me finish my question. So when you were referring to and using the word report, you meant the rebuttal for witness Larios, is that correct?
Yes.
Okay, all right, just want to make sure we're on the same page. So I think if you can, to the extent you can, and I know this is new, just please refer to the testimony when you're, instead of using the phrase report, just give us the rebuttal, state what document it's coming from in terms of the rebuttal or surrebuttal or direct testimony. Okay.
Thank you very much.
Sure.
Has Solar Maple given written agreements to homeowners in the past or in the current, for the current project? As far as homeowners who have not sold land to the project?
What type of agreements are you talking about?
Typically, the vegetative buffer agreements or setback agreements. Are there those agreements in writing?
I have not personally seen those agreements in writing, but I believe that Leeward Renewable Energy has executed those types of setback and vegetative buffering agreements in the past, perhaps not vegetative buffering agreements, I'm not sure. But for the Silver Maple Solar project, we have not.
Okay, thank you. The association question is, they're curious why you did not meet personally with us when you were deciding on further setback, and also, and we're very thankful for that. And also we're thankful that you have decided there will not be any construction the days of our event. We are thankful for that, but they felt that it would have been nice to have a meeting with you and discuss maybe a few other things as well. So is there a reason that you were not able to meet with us?
I am definitely willing to continue meeting with you, ma'am.
And we are happy to meet with you as well. So there was never, that's never been an issue that we don't refuse to. And that is all I have. Thank you very much.
Okay. All right, thanks. So we'll move on to our next party here, Renew Wisconsin. Any question?
None, Your Honor.
Okay, and the towns?
I've got just a couple of quick questions, if that's all right.
Yes, please, go ahead.
Mr. Larios, thank you for being here today. I'm going to represent to you that the main concern with the town residents.
Just introduce yourself to the witness.
Oh, sorry. Luke Martell on behalf of the town of Nekimi and the town of Eldorado.
Okay.
I'm just going to introduce, I'm going to represent to you that the main concern that I hear from the town residents is about soil contamination and soil quality. This is a large agricultural community. And so they're worried about those issues specifically. Is it your testimony that the soil will be returned to an as good or greater quality regarding crop production or things along those lines after the decommissioning of this project?
Correct. It is my testimony that through the planting of native vegetation throughout the project site, that once the project is potentially returned to agriculture, that the soil will have better organic conditions and that it will have been free of fertilizers macronutrients at that stage.
Excellent. And will there be soil testing done prior to the start of the project so that you understand what the baseline is of the soil quality? So you can relate back to that once the decommissioning happens.
There will not be soil testing prior to the project. As stated, the project will not utilize the volumes and quantities of fertilizers and macronutrients. So, and I believe that it is very well established that this provides for a better, healthier soil.
All right, I've got nothing further.
Okay, thank you. Commission staff.
Yeah, I just have one quick question. Hi, Mr. Larios, Zach Peters with the Public Service Commission. Are there any potential federal permitting needs for this project?
I believe I think the potential for federal permitting would come in at the wetland and waterway with the wetland and waterway subjects. However, I understand that the Wisconsin regulations essentially would take place of those federal permits, or that there will be perhaps needed consultation with federal authorities regarding these two subjects.
Okay. No further questions, Your Honor. Thank you.
Okay. So I guess I just had a follow-up for that. My understanding of the application process is that the applicant identify all permits needed. Is that not settled yet, or is it depend? I mean, well, I guess what does it depend on if that issue isn't settled?
We did state the potential permits in the CPCN application, Your Honor, and I believe that the final determination is based on the amount of area that could be impacted based on final design. However, I think I'm not sure if this is Ms. Kuhn's expertise, and I would sort of defer to her, sir.
Okay.
I'm sorry, Your Honor.
That's fine. Don't worry. So yeah, I was just curious if the final design is something that's in the applicant's control, or would the permit issue relate to citing that the commission has discretion on? So in other words, is it that the commission may place an array and approve an array that would then require federal permitting, or is, regardless of what the commission might approve, would the applicants have a choice to utilize the project area in such a way that it would require federal permitting?
It is my understanding that DNR is the agency with which we would be most closely in contact in order to work through these issues. And then my understanding is that at that point, sort of the issue of whether a federal permit is required or not would be resolved.
And then I guess I had another question related to this federal question here. And that is, it appeared from your answer a while back that the applicant is not anticipating that this project will be federalized, I guess we could say. But I know that it's been happening lately in some solar cases and other utility construction projects, that the new Infrastructure Investment Act has, I'm sorry, that's pretty funny that I called it that. The IRA, the Inflation Reduction Act, which can also be considered an investment act, but that particular federal laws, utilities seem to be utilizing and proposing to fund projects through that new process. And to the extent that would this project be eligible for funds through the IRA?
To the extent that I know, the project could potentially be eligible for a few of the clauses, a few of the benefits included in the IRA. Those clauses include the promotion of domestic content, and I believe that every single IPP is looking to ensure that we take a look at the clauses of the IRA and develop an efficient, responsible project, sir.
Okay. So as you see here today, what's the likelihood that Silver Maple Solar would be eligible for IRA funding?
I do not believe that IRA funding is the appropriate term.
Okay, sorry.
I believe that we will avail ourselves of the regulations as they are prescribed and further detailed in legislation that explains how to go about interpreting those regulations.
Okay. So is it fair to say that if Silver Maple Solar is eligible, it will apply for whatever benefits are provided by the IRA?
I think it is fair to say that Silver Maple Solar will optimize its project development and construction.
In relation to the IRA?
Yes, sir. In relation to the IRA.
Okay. And if that does occur, what process does the applicant propose to take in terms of informing the commission about any new requirements that it may need to fulfill based on that decision, and if eligible, and if it receives benefits from the IRA?
I think that I think we would propose to follow the rules and regulations described in the IRA. I don't know what, if any, other requirements exist or are needed.
Okay, fair enough. All right, I think that's it for me. Thanks, and redirect.
Thank you, Your Honor. Just one brief question, Mr. Larios. Ms. Schultz asked about your testimony, but is it accurate to say that in response to data request 4.10, you provided details on your meeting with the Chapel Association, including that other association members were there and that you spoke about the history? Is that accurate?
Yes.
Thank you. No more questions, Your Honor.
Thanks. All right. Well, thanks very much. You're excused.
Thank you, Your Honor.
So is that the applicant's witnesses?
Yes, Your Honor. That is all of our witnesses.
All right. Well, let's plug along here. So to the extent that we need to take them, does Clean Wisconsin wish to call?
Yes, Your Honor. Clean Wisconsin calls Dr. Paul Mathewson.
There you are. All right. Raise your right hand and do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Could you please state your name for the record?
My name is Paul Mathewson.
And Dr. Mathewson, are you the same Paul Mathewson that prepared and caused to be filed direct, rebuttal, surrebuttal testimony, 26 associated exhibits, and errata to your direct testimony in this docket?
I am.
Other than the correction to your direct testimony provided in an errata sheet, do you have any other corrections to your testimony?
No.
To the best of your knowledge, are the answers you provided in your testimony true and correct?
Yes.
Thank you. Regarding the conversation that just happened around your Exhibit 22. Could you explain your use of the Inspire Low Impact Solar Development Strategies Primer, excerpts of which were submitted as Exhibit CW Matheson 22 in preparing your SIR rebuttal testimony?
Yeah, the intent of that was just to provide support and to inform my recommendation from my direct testimony regarding best management practices to reduce soil compaction. Namely, this Inspire document talks about avoiding and minimizing construction during wet and rainy periods.
Thank you. And in your opinion, can a utility scale solar project such as Silver Maple be environmentally beneficial even if it doesn't meet all of the criteria listed in your Exhibit 22, the criteria that Mr. Larios went through point by point just a little bit ago on the stand?
Yeah, it's my opinion, you don't need to meet every single point in here, but you know, it's a spectrum. And you know, as I talked about in my direct testimony, Silver Maple proposed project, you know, if it's implemented as proposed, we should substantively meet many of these low impact solar development standards and provide multiple net environmental benefits over the current land use.
Thank you. No further questions, Your Honor.
Okay, great. Cross, we'll start with the applicant.
None from the applicant, Your Honor.
All right. Chapel Association. Oh, do we have? Oh, there you are. Thought we lost you there. No questions. Okay. Renew.
None from Renew, Your Honor.
And the towns.
Nothing from the towns.
Commission staff.
No questions.
All right. Okay, thanks. You're excused.
Thank you.
So we'll move on to the Chapel Association. So Ms. Schultz, are you ready to go? I'm going to swear you in and have you verify your testimony. So you yeah, there's good to go. You're good to go there. All right. So raise your right hand. And do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
So help me God. Yes, I do.
Okay. State your name, please.
Carol Lee Ann Schultz.
And are you the Carol Ann Lee Schultz that submitted direct SIR rebuttal and 3 exhibits?
Yes, I am.
And are those documents complete and correct to the best of your knowledge?
Yes, they are.
Okay. Do you have anything you'd like to add based on the filings of SIR rebuttal and what you've heard today at the hearing?
Yes, I do have things to add.
Okay, go ahead.
So I have been, well, you have read my testimonies, et cetera, and know my credentials and things like that about being president with Peniel and my years with them. And I have grown up in the area, and so I know the land very, very well. And I farmed there with my father. And I am passionate about preserving the Oshkosh settlement, any farmland out there, basically, also. But we are to be good stewards of what the good Lord has given us. So that is in a nutshell there. I do have a SIR rebuttal I would like to read.
Yes, go ahead.
Okay.
Just be slow when you read so we can
Sure.
we can type everything down.
This is a SIR rebuttal testimony by Peniel Welsh Chapel Association. Are you the same Carol Lee Schultz who provided direct and SIR rebuttal testimony on behalf of Peniel Welsh Chapel in this matter? Yes. Have you previously provided pre-filed direct and SIR rebuttal testimony in the proceeding? Yes, I have. What is the purpose of your SIR rebuttal testimony? The purpose is to respond to the SIR rebuttal testimonies of SM, Silver Maple, Solar, Horatio Larios, and Sarah Nelson. Have you reviewed the SIR rebuttal of witness Horatio Larios in relation to Peniel Welsh Chapel? Yes, I have. Has the viewshed impact to the chapel been addressed satisfactorily? No, it has not. Mr. Larios refers to Westwood employed Sarah Nelson's historical analysis. He claims, quote, Silver Maple Solar made significant efforts to avoid and minimize potential impacts to the Peniel Welsh Chapel, including during initial design phases of the project when the layout, I'm sorry, I didn't end the quote after chapel. including during initial design phases of the project when the layout was adjusted to increase setbacks in the Surrey Rebuttal SMS-Larios 2. We understand that the additional setbacks have been developed to the west of the chapel. We only learned of this via continually monitoring the documents and exhibits submitted to Public Service Commission. But as easily as these changes were made, we are worried that what is to prevent them from being rescinded and possibly being made more detrimental to the chapel in the future than in the original drawings. We are realistic and operate on goodwill. To us, goodwill on the part of Silver Maple Solar and Mr. Larios would have been the reasoning behind what could and could not be done. What considerations were being offered, vegetation species, including type, growth, and installation time, along with a concrete written agreement as to what was determined and promised for these concerns. Question: do landowners have the right within reason to use or dispose of their property as they see fit? Answer: yes, they do. Especially in these hard economic times, the allure of cash for either the sale or lease of property is seductive. Add no realtor fees, advertising, or preparing for showings makes these offers even more attractive. The constant government promotion of green energy and the bashing of fossil fuels has created a strong public following. What's too often missing are the personal research of the pros and cons of solar, the realities of the efficiency of solar in a climate such as ours, the subsidy amounts given to these projects, the possible supply chain issues in completing such a large project, and what other countries are benefiting from these projects. Question: is it true there is no information refuting Silver Maple Solar's experts' environmental assessment's conclusion of no significant impact to Pennywell's Chapel? Answer: we are volunteers without a stable of solar company employed staff with credentials for each area of concern. Had a representative or representatives been at any or all of our 2023 public events, they could have the opportunity to interview attendees where opinions about the impact of the solar farm would have been voiced. We would gladly have provided a space for them to present their proposed site maps and brochures. Have you reviewed the cerebuttal of Sarah Nelson in relation to Pennywell's Chapel? Answer: yes, we have. Question: are witness Nelson's conclusions pertaining to the environmental assessment without bias? Answer: we would like to think so, but her belonging to Women of Renewable Industries and Sustainable Energy Minneapolis chapter and being employed by Westwood, who is the company associated with Silver Maple Solar, seems to create a conflict of interest. Question: have you received or seen a copy of Witness Nelson's formal cultural resources desktop review? Answer: no, we have not. We only have the narrative information provided in Witness Nelson's rebuttal, which is rebuttal-SMS-Nelson, page 2. Question: have you received or seen a copy of Witness Nelson's architectural history survey, photos, and other associated reports? Answer: no, we have not. The rebuttal states that a windshield level survey was done initially with reconnaissance level survey conducted next. Finally, there was an intensive survey level 2 review, a National Register of Historic Places evaluation, where Pennywell's Chapel and Bethesda Church were deemed potentially eligible for this historic designation. We have been able to locate other reports online that Ms. Nelson has filed in the past for various agencies, but we only have a narrative of these works involving Pennywell's Chapel as described in her rebuttal. Question: have you accessed the Wisconsin Historic Preservation Database to view the described amended and or created WHPD entries with the information and photographs that were gathered during these surveys? No, we have not been able to. We have accessed their website, but there is a charge to view information held there, as well as the requirement to first become an authorized researcher. And if I could add, those charges are exorbitant for our chapel treasury. The Wisconsin Historical Preservation Department states that ongoing projects, work demands, staff shortages, or schedule constraints take precedence, so being designated as an authorized researcher isn't immediate. Once designated as an authorized researcher, we could make an appointment and go to Madison to view the database, but that is a distance, and we were at the time of the year where farms, vegetable gardens, and food processing, besides daily employment, make it difficult to travel and schedule a viewing time. As we've mentioned in previous testimony, we are an entity whose funding is donation-based. The charges that would be incurred would have to be voted on and fit in our priority list where maintenance of the chapel supersedes all other expenditures. Are there other sources that could have been pertinent to witness Nelson's various reviews used to make her determinations? Answer: yes, we believe there are. First, since it seemed she travels to the area, taking time to meet with any board members would have given her further insight into the community and the historic relevance of Peniel Welsh Chapel. That would have fit.
I'm going to interrupt for a second. Just slow down a bit when you're reading. Okay.
Sorry. Okay, thank
That's
you.
fine.
Answer: yes, we believe there are. First, it seems she traveled to the area, taking the time to meet with any board member or members would have given her further insight into the community and historic relevance of Peniel Welsh Chapel. That would have fit into the parameters of the intensive survey manual published by the SHPO. It would also have allowed her to view in person the interior of the chapel and the actual views from the entry platform and from the windows in the nave and fellowship hall. Views which we provided in Exhibit Peniel-Schultz 2, and that's the PSC reference 481393. And secondly, the history of the Oshkosh Welsh settlement, the book 1847 and 1947, written by Howell D. Davies in 1947. This is a significant reference. This book is such a significant reference that it has been reprinted and is available for sale. But for an architectural history survey writer without physical access to the book, it can also be downloaded at search.library.wis.
I'm sorry. I'm sorry. At what library?
Downloaded at because she does not have access to the book in a library, she could access it at https://search.library.wis.edu/AZMBUASO-X6FU7J9C. This book includes chapters on the geography of the settlement, the first beginning of the settlement, the agriculture of the settlement, the churches, farm life in the Welsh settlement, as well as brief biographies of the early settlers. Question: has witness Nelson's survey of the surrounding area addressed views in each direction from Peniel Welsh Chapel? Off the record, we did not know that she was out of her car. So this was written before. The answer was no, it has not. If read casually enough, compass directions are mentioned that it is easy to miss the one with the most impact to the chapel, the northeast. Ms. Nelson states, quote, there will be no project infrastructure directly northwest, north, south, or east of the chapel. Views of arrays to the northwest and west would be minimized by vegetative screening, unquote. Sir Buttle, SMS, Nelson, page 10. The view to the northeast is never mentioned. This is the view that is seen from the elevated chapel entrance, from the eastern windows in the nave, from the northern and eastern windows of the fellowship hall, from the concrete outdoor gathering area, from the parking lot area, and as cars approach chapel from each direction. Question: do you have concluding statements? Answer: yes, we do. Silver Maple Solar LLC knows we are a small entity where volunteers make up the board and perform other needed tasks. We all are devoted to Peniel Welsh Chapel. We recognize that societal progress often comes with changes. We desire those changes to be based on science, past practice reviews, and analysis, with a mindset that explores and predicts possible unintended consequences. Throughout this process, we have not received the benefits of legal counsel that were initially described in the project proposal. We've been told we aren't being good neighbors by asking for restrictions on the footprints of the solar farm and being accused of limiting the owner's decision on their property. We believe that to be a good neighbor, or to have a good neighbor, you have to be a good neighbor. It is our belief that SMS has no interest in being a good neighbor to Penny Welsh Chapel. If that wasn't the case, they would have been transparent and provided us with the various reports and documents their staff has generated. They would be open with describing the buffers, fencing, and types of vegetative screening they will employ more thoroughly. If SMS's proposal and following testimonies, rebuttals, and surrebuttals are read carefully, there are too many nebulous assumptions. Many of their comparison studies use data from smaller solar farms. They contradict verified resources about the prevention of oak wilt, impact to migratory birds, and want best practices changed for their convenience. They have not fully addressed runoff and compaction. They have played the elimination of fossil fuels cards to extol the virtues of solar to the government, localities, and individual landowners to their advantage. We think people have been led to believe that at the end, at the solar farm's life, decommissioning will return the land to what we see today. So why worry? Solar farms are too new of a technology, have concrete data on what decommissioned land will actually be. All of these reasons are why we have asked for written agreements with Silver Maple Solar LLC. Does this conclude your surrebuttal testimony? Yes, it does. And again, I would like to state this is not only my writing, this is the association and various members got together to write this and to edit it.
Okay, thank you.
Sorry it's so long.
That's all right. So I did have a couple of clarifying questions, and I think we may have been, you may not have been fully informed of our process, and for that I apologize, but we do have the documents you referred to in terms of the cultural resources desktop review and the agricultural history survey or historical survey, and they were filed on the commission's website and also included in the application exhibit, so they can be viewed by searching the docket on our system and downloading those files. So they've been available since the application was filed, and it's unfortunate that you didn't realize that they were available to all public, any public person could view that since that time. So so in terms of your contention that the applicant didn't provide it, I just wanted to clarify that it was available to the public, and maybe there was some misunderstanding or lack of information provided to you. Another aspect of this was in terms of the files that the applicant, the responses to data requests that the applicant provided in the case, they are also all on the commission's website, and I believe should be served to all parties. So there should be you should have received a copy of, for example, the one that we've been discussing, the response of the applicant to staff request AC 6.1, which was I guess some people are referring it to kit symbol 6.1. That's to the best of my knowledge should have been emailed to you, and was also provided on the commission's website. So I know there has been some issues about whether this is in the record, and I've tried to clarify that during the course of the day that this is part of the record, will be offered in the commission's exhibit. That contains all of the data request responses that staff had asked for. But that was available. I was just curious, Ms. Schultz, have you seen this document before today?
No, I have not.
You have not. Okay, well, that is not really a great
I would
result
like,
in
I
our
would like
process.
to, excuse me, I would like to clarify that, I should just say, I would like to state that I have not been receiving regular emails. It's been very spotty, and talking with other party members that they let me know, "Oh, there's another one," and I look and there's not even in my junk mail or anything. So I have not received all the regular emails that I should have been getting.
Okay. And I was just curious then if we looked at this document, this response from the applicant that involves the vegetative screening for the Welsh Chapel. Can you see that on the screen?
Yes.
So I just noticed on the bottom corner, the right-hand corner on the bottom is there's a word for this, the compass directional indication here. I'm not providing the right word for that, but it does point north is at the top of the page. Do you see that?
Yes.
North is indicated at the top of the page. So I wanted to clarify your testimony, because I know the concern that you've expressed, that in your impression is the applicant did not address or seems to not be speaking about, and it seems to be the concern that you have the most. When I say meet you, I mean the association. The association is most concerned about the view towards the northeast. Is that correct?
Well, outside of the west, of course. I mean, that's been addressed already, but the northeast has not been addressed.
Okay, so that just confuses me a bit, because in my view, northeastern direction would cross Zora Road and be looking out into the field into the north.
So your cursor is going west.
Oh, I'm going west. You're right. See, that's why I'm confused. So northeast, yes, you're right. So it's going northeast, cross Zora Road. And I'm just not sure, in your mind, in the association's opinion, what is the impact of the project on that view? Because I don't see the project being proposed.
So this map is not a full view.
Okay.
The land that you're pointing to right now is not in the project, but directly to the right of that, to the east of that, it is, and it's a very large area.
Okay, good.
And it's on a hill.
Okay, good. All right, that's all I have for you. So let's have any cross for this witness. We'll start with the applicant.
No cross, Your Honor.
No, okay. And Clean, Wisconsin. Yes, right. Clean, Wisconsin, you're next.
No questions, Your Honor.
All right. Any questions from Renew?
No questions, Your Honor.
Commission staff?
No question.
Oh, and the town, sorry. Questions from the town?
Nothing from the towns.
Okay, sorry. All right. Okay, then did
Is
you
it
have anything?
possible for me to make another comment?
Well, if you could, if
I'm
there's
done.
something you'd like to clarify from what I've asked you, yes, but you'd have to keep it limited to the questions I've asked you.
Okay, never mind then. I'm done.
Okay, all right, thanks. So, and let's go off the record, just so you may not be familiar with our process going forward from this point on, but it's appropriate for me to inform you that, so we will get all the evidence in the record, including a transcript of the hearing. And at that point, once the evidence is collected, parties will be expected, or they have the opportunity to file briefs in the case, which is, I don't know if you're familiar with that
Not really.
terminology, but it's a document in which a party can express its arguments in favor or against the proposal, given the evidence that's been received in the proceeding. So that's an opportunity for the association to express its opinion. Given in and reflect on all the evidence that's provided. So although you have nothing left to say factually, there's still an opportunity to provide your opinion on the case in the brief. Okay.
Thank you very much.
Okay.
And sorry
Okay, so-
again for the, no.
No, that's fine. This is not easy for the newcomer. I know that. Okay, so let's move on to renew. Did we want to call witness?
Are you back on?
Yes, we're back on. Sorry.
Go ahead.
So witness Vickerman, did you want to appear today?
Yes, Your Honor.
Not seeing your attorney there. I don't know if if his screen's frozen. Oh, there we go. Excellent. Okay, so let me swear in witness Vickerman. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, go ahead. Okay, so if you want to introduce your witness, Attorney Valsic. Can you hear me? Attorney Valsic, can you hear me?
I can hear you.
Okay.
Everyone is frozen. I'm sorry. My internet appears to have dropped out at the moment.
Oh, boy.
Can you hear me?
Yes, we can hear you. You're moving. So
Okay.
we'll take it from
Awesome.
here.
All right. And Mr. Vickerman is available, I'm assuming. I can't see anyone.
Oh, yeah, we've sworn him in, and I've just passed him on to you for introduction.
Okay. Thank you. Good morning. Good afternoon, Mr. Vickerman. Could you please state your first and last name for the commission?
Michael Vickerman.
And did you cause to be filed written direct testimony along with the exhibits Renew-Vickerman 1 through 3?
Yes, I did.
And if I asked you the questions in written testimony today, would you respond the same?
Yes.
And is all the information offered in your testimony and exhibits true and correct to your knowledge?
Yes.
Do you have any more information to add?
I do not.
All right, Your Honor, I'd move those 3 exhibits into evidence.
Okay, yeah, the offered evidence has already been received, and we just had it verified, so it's in the record. And so that's witness available for cross?
Yes, Your Honor.
All right, so any cross for this witness? I'll just ask, generally speaking here.
Not from the applicant, Your Honor.
Anyone else with questions? No? Okay, thanks very much. You're excused.
Thank you, Your Honor.
Take care. Okay, and Town of Nekimi. Do we have witness Barthels? Am I saying that correctly?
Yes, he might be in your waiting room. I think he was
Oh.
trying to connect here.
Oh, not.
You could check.
Yeah, I haven't seen him. I usually get well, I may have been asking questions. But
Do you want to be off the record?
yeah, that's good.
Okay.
Yeah, well, I'll send him a
Yeah, I
follow-up
don't-
text here. I think
It's
he was trying to.
I mean, I don't think we have cross. He has been, is that, if I remember correctly, I don't think he needs to appear, but if you want him to verify testimony live, that's possible.
Yeah, I was going to, but if we aren't able to connect him, then I suppose you can move on in the interest of time.
Yeah, why don't we move on? If he does happen to join us, we can take him at a convenient time. So
Excellent, thank you.
Yep. So let's move on to commission staff. Get on the record. So I just wanted, before we take a witness, I just wanted to, no, there he is. All right, let's just get him done.
All right, thank you.
Okay, witness Barthels, I see you joining us here. Your audio is connecting, so it may be a minute. There we go. All right, well, if you could unmute, I'll swear you in. Do that myself. Okay. All right, got you unmuted there. Let's just test out your microphone, Glenn.
Okay.
Sounds good. All right, great. So I'm going to swear you in. Ask you to raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, so I'll pass you on to your attorney.
Thank you. Good afternoon, Chairman. Can you state your full name for the record, please?
Glenn Barthels,
What is your position with the town of Nekimi?
chairperson.
Have you prepared and caused to be filed in this matter direct testimony on August 15th of this year that consisted of 9 pages?
Yes.
And does your testimony today remain the same as in your written testimony?
Yes, it does.
No further questions.
All right, so witness is available for cross. Don't think there's any, but I'll ask now that we're here. No? Okay, thanks very much. You're excused.
Okay, thank you.
Okay, so let's move on to commission staff.
Okay, Your Honor, the commission would call Jeree Rodemacher to the stand.
And, you know, before we get there, I did want to address, I'm just going to stop your video. And I just wanted to address the potential exhibits we have from staff, which is the data request response and the public comment. I didn't see the data request response in yet, so I just wanted to verify that that was that would be it's pending filing, and what the contents will be. I think probably Attorney Peters, you can just, if you just speak to that quickly.
Sure. Yeah. So the delayed exhibit data request response exhibit will be filed and will contain the data request questions filed by commission staff, and then the associated responses with links to those documents on Earth. The public comment document, once that comment period officially ends, those public comments that exist within, or that were, filed within the specified time period will be collected and submitted as a delayed exhibit. And additionally, Your Honor, as I was going to have be introduced by witness Wu when he's on the stand, there will be a another delayed exhibit presented by commission staff in this proceeding. That's going to be an exhibit simply containing the completeness determination as issued by the commission. We believe that that should be present in the record, and it's kind of a strange procedural thing in which it's issued before the notice of proceeding. And so we would like to enter that as well. And I can have witness Wu speak to that in terms of verification when he's on the stand.
Okay. You know, I just had another totally separate question for you. I know staff had expressed in general, in terms of the these solar applications, to have and I think it is in the data request requests and responses, relates to the joint development agreement that usually gets produced in these during the course of these proceedings. I'm just curious, in this case, did staff ask for that to be filed, and do you know the status of what's happening?
I don't know off the top of my head at the moment, Your Honor, but could look into that.
Okay, well, maybe let's just ask the applicant then, because I know that was one of those other procedural documents that staff was looking for in other cases. I guess the commission really was interested in other cases, so we were going to pursue receiving those. And so I don't know, Attorney Brewer, if you have any information, and I know this is really off the cuff here, but if you could just, if you can today or now, answer that question, or at least refer us and give us an answer in the future. But the Just curious, in terms of if there's a joint development agreement and the status of that.
Yeah, Your Honor, we have not been asked about the joint development agreement in the record from staff to date.
Okay.
And not anticipated filing that information.
Mhm.
Frankly, I'm not sure there will be anything to file before the application would, the project would go to the commission.
Okay, well, yeah, I'll leave it up to staff if they wanted to follow up with a data request about that, but I know that they were trying to come up with a consistent practice, at least requesting information about it. So it's possible that didn't occur here. So I'll just leave that up to staff if they want to follow up. Okay, great. So let's take our witness. So we have witness Rademacher there. So let me swear you in. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, and nothing but the truth. Oh, I can't hear you, and you're not muted. There we go.
Probably,
it's
maybe I need a drink of water.
Oh no.
Let me take one.
I think it's those headphones. They always get me in trouble.
Can you hear me better now?
Yes, perfect. All right.
Perfect. Thank you.
So in terms of your truth and veracity of your testimony, do you, let me just ask it again. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
Yes.
Nothing like those famous words. So, okay, go ahead. Turn you over to Attorney Peters.
Please state your name for the record.
Jeree Rademacher.
And what is your position at the Department of Natural Resources?
I am a water management specialist within the Office of Energy.
And how are you involved in this docket specifically?
I was the DNR PSC liaison, and I also reviewed the project for compliance with waterway and wetland regulations.
And did you file or cause to be filed both direct and rebuttal testimony in this docket?
Yes, I did.
And are the statements and representations in the testimony you filed in this case true and correct?
Yes, they are.
Do you have any additions or modifications to your testimony at this time?
No, I do not.
Thank you, Your Honor. The witness is available for cross-examination.
Okay, questions? We'll start with the applicant.
None from the applicant, Your Honor.
Okay, any questions from interveners? No, seeing shaking heads. Okay, then that's it. You're excused. Thanks very much.
Thank you.
Next, Your Honor, the commission would call Stacy Rowe to the stand.
Okay. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth.
I do.
All right, go ahead.
Please state your name for the record.
Stacy Rowe.
What is your position at the Department of Natural Resources?
I am an endangered resources utility and transportation liaison.
And how are you involved in this docket specifically?
I reviewed the project for impacts to rare and non-game species.
And did you file or cause to be filed both direct and rebuttal testimony in this docket?
Yes, I did.
And are the statements and representations in that testimony true and correct?
Yes, they are.
Do you have any additions or modifications to your testimony at this time?
No, I do not.
Thank you. Your Honor, the witness is available for cross-examination.
Okay. Before I ask that, I'm just going to go off the record for a second. So, Attorney Valsic, I just want to make sure you're still connected because I don't see your video.
I am, Your Honor.
Okay, good. All right. I'll make sure we want to keep that on. As the attorneys, I make them leave their video on. Witnesses can chime in when they need to. But okay, so let's get back on the record. Any questions for this witness? No. All right. Thanks very much. You're excused.
Thank you.
Next, Your Honor, the commission would call Samantha Whitens to the stand.
All right. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, good. Go ahead.
Please state your name for the record.
Samantha Whitens.
And what is your position at the Department of Natural Resources?
I am a water resources engineer.
And how are you involved in this docket specifically?
I reviewed the project for compliance with state stormwater regulations.
Did you file or cause to be filed both direct and surrebuttal testimony in this docket?
Yes, I did.
Are the statements and representations in that testimony true and correct?
Yes.
Do you have any additions or modifications to your testimony at this time?
No, I do not.
Thank you, Your Honor. The witness is available for cross-examination.
All right, any questions? No one? Okay, thanks very much. You're excused.
Thank you.
Next, Your Honor, the commission would call Chang Wu to the stand.
Right. There you are. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth? Okay, your audio is a little tricky to hear. Maybe getting closer in. Let's test that out.
Does this work?
Not quite working, no.
Is this better?
Yeah, yes, I think so. Can we see your face? Yes, let's try to get your face in line there. And just give us a test 1, 2, 3.
Test 1, 2, 3.
It's a little choppy. Oh, really not great.
That might just be my.
I don't know if we have many questions for you, so I think we can probably limp along with the connection you have, but we'll see how that goes. So let me swear you in. Raise your right hand. Or do we do this already? I don't know. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, great. Okay, go ahead.
Please state your name for the record.
Chang Wu.
And what is your position at the Public Service Commission of Wisconsin?
I am employed as a public service engineer.
And how are you involved in this docket specifically?
I reviewed the technical and engineering aspects of the project.
And did you file or cause to be filed both direct and surrebuttal testimony in this docket?
Yes.
You also file or cause to be filed exhibits marked EXPSC Wu 1 through 3?
Yes.
And are the statements and representations and the testimony and exhibits that you filed in this docket true and correct?
Yes.
Do you have any additions or modifications to your testimony or exhibits at this time?
No.
Mr. Wu, are you familiar with the completeness determination process conducted pursuant to Wisconsin Statute 196.491 in dockets such as this one?
Yes.
And was a completeness determination completed in this docket?
Yes.
When was that completeness determination issued?
It was filed on Earth as Earth number 462374 on March 23rd, 2023.
Does commission staff intend to submit that document into the record?
Yes, commission staff intends to submit a delayed exhibit, exhibit PSC completeness determination to the record following this hearing.
Does commission staff intend to submit any other delayed exhibits into the record?
Yes, staff will also be presenting the data request exhibit and public comments exhibit.
Thank you. Your Honor, at this time, the witness is available for cross-examination.
Okay. So I just had a quick question, and maybe this is for Attorney Peters, but so naming the document completeness determination, I guess that's not a document we already have contemplated. Is that something that staff's already produced like a template for with that nomenclature?
No, Your Honor, we could
okay, so
certainly
let's
change the naming convention as you see fit.
Okay, so let's make that Wu 4, and I think we can add that in as a what I'm calling special exhibit, something that's predetermined. But I would like to change the facilitating matters order to reflect that new requirement or new expectation. So let's just for now just call it Wu 4, and yeah, we just need to coordinate. It would be useful to have a little bit more of that going on. And so just off the record, can I just get the PSC number again?
Yes, Your Honor. Hold on, I have it here. I believe it's 462-374.
Okay, excellent, thanks. Okay, so back on the record, witnesses available for cross, so any questions? Nothing, huh? Okay, great, you're excused, thanks very much.
Thank you.
Next, Your Honor, the commission would call Andrew Kraft to the stand.
Okay.
Is it working?
No video yet.
Okay. Okay. That's weird.
Do you have something covering your camera? Because it looks like your video.
No. I thought maybe, are you blocking my camera, the people's camera, to allow it?
No, I don't really have control over the camera one way or another.
Can test my camera. I did earlier and it was working just fine.
Okay. So let's do this. Let's go off the record and have you disconnect and reconnect because I think it would be useful to have you on the screen.
Leave and come back.
Yeah, leave and come back.
Kind of eerily quiet. Can you hear me?
Yes. We're all
Okay.
very tired of talking.
Well, I know, but it just was like weird quiet. And I'm like,
Oh, yeah, right. Yeah. So I hate that. All right, we'll see how this goes.
Is it working now? Oh, when I saw the preview, yeah, my camera was working. So
it's telling me to ask to start video. So I'm going to push that and maybe you'll get some notice on yours. Oh, wait, are you there? I'll ask you to start video.
Start.
There you go.
Okay, sorry about that.
You're still not on the screen though. All right, well, I think we'll just have to live with this.
I could try calling from my phone if you'd prefer.
Well, the audio is coming through, so that won't solve the video problem. So that's fine. Let's plug on then. So I'll ask you. I'll swear you in. Please raise your right hand. And do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, go ahead.
Please state your name for the record.
Andrew Kraft.
What is your position at the Public Service Commission of Wisconsin?
I'm an environmental analyst and the historic preservation officer.
And how are you involved in this docket specifically?
I coordinated the EA and the SHPO review.
Did you file or cause to be filed direct and surrebuttal testimony in this docket?
Yes.
Did you file or cause to be filed exhibits marked EXPSC Craft 1?
Yes.
Were you also involved in the creation and filing of the exhibit marked EXPSC EA?
Yes.
With regards to the exhibit filed as Craft 1, could you please describe the process by which this exhibit was created?
Sure. Do you mean the SHPO review process?
Yeah.
Why it was created?
Could you please explain the process by which the contents of the exhibit were initiated?
Sure. So that's the standard form that is used to do the consultation between PSC and SHPO, or really any state agency. It's a form I fill out. I attach the application materials and send it to SHPO. SHPO reviews that and then sends back a response. So the purpose of putting it as an exhibit is to have that in the record.
Do you undertake this process in all of the dockets that you participate in?
No, only dockets that there's a historic property that may have an adverse effect. Typically, that's when this occurs. It doesn't have to be, it's not always the case. Sometimes we also do it just to have SHPO's opinion on the matter. Yeah.
And at the commission, are there other individuals who submit these or who reach out to SHPO for these evaluations?
No, that's in statute. It's just the person designated as the historic preservation officer, and that's me.
And what is the criteria you follow for determining that such a review may be required?
The statute says that if historic property may be adversely affected, then we're required to do this review.
What statute is that?
4440.
And do you do these reviews of the criteria or requests for evaluation from SHPO regularly?
Yes, this is a regular occurrence.
And have you received training on how to evaluate such criteria or reach out to SHPO for such potential evaluations?
Yes.
Do you have any other information to provide to explain the process by which you obtained this particular review or evaluation?
I think I described that in my surrebuttal. I'm not sure if there's anything that needs clarified in there.
Okay. And are the statements and representations in your testimony and the exhibits that you filed in this case true and correct?
Yes.
Do you have any additions or modifications to your testimony or exhibits at this time?
No.
And one final question, Mr. Kraft. Are you in regular contact with individuals at SHPO?
Yes.
And is it I guess, is it the same individuals that you work with regularly on these evaluation requests?
Yes, SHPO has a reviewer designated to work with state agencies. So that's who I work with.
Are you familiar with the evaluator that responded to your request in this situation?
Yes.
Have you worked with them before?
Yes.
Would you say that you've worked with them regularly?
Yes.
No further questions at this time, Your Honor. The witness is available for cross-examination.
Okay. So I think what we want to focus on first with cross is the foundation and the sort of these fundamental questions about the document and the process for historic preservation. And I think the applicant possibly have questions about that. So I'm going to allow you to do that. And then we can we can see how that affects any, how it impacts the motion to strike the documents. So any questions from the applicant?
Yes, Your Honor. Thank you. Good afternoon, Mr. Kraft. Delaney Brewer with Silver Maple Solar. So you describe, just referring to exhibit 1, your exhibit 1, you describe this as a completed PSC-SHPO historic review in your testimony. Is that correct?
Yes.
how did you submit this request to the State Historic Preservation Office?
Via email.
And was there a message included with that email?
Yes. Yep.
Do you recall what the message said?
So there's a cover letter that goes with this form with instructions on what to include, and so it's there was the application materials, the architectural history review, the Peniel Chapel's response, talking about how the visual impacts would occur, and then let's see. Then I think there was maybe the data request that I asked. It's basically just the background information the same information that I look at.
So to clarify, it wasn't the entire application, or was it the entire application?
No, no. Usually it's not the entire application. Usually in the cultural resource reports, there's enough background information there on the project for SHPO. But they can ask me for more information if they have any other questions.
Did they ask for more information in this case?
No.
Did you provide any of the applicant's testimony?
Oh, I don't believe so. I think this was before testimony.
When did you email this to?
August 31st, looks like.
So did you provide the Peniel Welsh Chapel's direct testimony when you emailed it to SHPO?
There was something that was on IRF that they submitted. I think it was marked incorrectly, but I think it ended up being their testimony later at a later date, and that's what I sent. It was the chapel saying basically that they thought the chapel would be affected, and maybe saying that the vegetation buffer wouldn't be enough to mitigate those impacts.
Do you know if the reviewer looked online at the applicant's testimony when they were doing their review?
I don't know.
The reviewer. Do you know if the SHPO reviewer looked online at any of the other information publicly available during their review?
I don't know.
Website? Do you know if the SHPO reviewer looked at any information outside of the commission docket for their review?
I don't know.
You know, I think I've heard enough to to kind of come up with a solution here. I did have one question for the witness before I do that, and that is, witness Craft, can you see the email, the page 2 of your Craft 1 on the screen, or do you have that on you? So the determination that's being made by the State Historic Preservation Office is that there's no adverse effect on the property in question if the following conditions are met. At least that's the substance of what it's saying. And one of those is, well, there's two conditions that we can all see. And I mean, do you in your experience and your expertise know the reasoning behind those particular conditions, why would the Historic Preservation Office impose those conditions?
I think that the visual effects may affect the historic property and its eligibility for the National Register. Putting vegetation screening would still introduce new visual effects, but they would be, it would screen out sort of more of the extreme ones, which are the kind of industrial view of the solar panels, and create more of a natural barrier. So it would reduce those effects.
And how do you know that's what the reasoning is behind?
I emailed SHPO after receiving some of this testimony from the applicant and said, this is what they're saying about it. And so SHPO responded saying some of these.
Okay, so this email wasn't, so for page 1 is your request.
Correct.
And the second page, that's the response to the request?
Correct.
It's not a response to a different email?
No, this is just the official request and official response.
But in the meantime, you had email exchanges between yourself and this Felipe Avila?
Correct.
Okay, and that's not being provided on the record so far? You haven't offered that?
Yeah, the purpose was to show that this review had been done and that these are SHPO's recommendations.
Okay, so I think we're not going to be dealing with this today. And I was just curious, Attorney Peters, did you advise the staff on this matter, or is this as much of a surprise to you as it is to me?
The filing of the letter itself, I was unaware of prior to its filing.
The letter being the request?
This request, yeah, the substance of the exhibit itself.
Okay.
I wasn't aware of the prior communications or more extensive communications with SHPO. But in terms of supporting the surrebuttal testimony of Mr. Kraft, I advised submitting it to the record as best we could. And that's, and I certainly, as a legal representative of the commission, reviewed the witness's surrebuttal testimony as it came through. And so the attempt there was to support that surrebuttal testimony with this document, having been already filed on Earth. And that's where we're at.
Okay, so I'm going to, I think we're going to have this information in the record one way or another. So to that extent, I'm going to deny the motion. But I think we need to back up and we need to provide, and I'm going to ask you, Attorney Peters, to develop a document that contains, a much more complete view of this. And if you want to work with parties to do that and just come up with something that can be agreed to in terms of what information needs to be provided, how it should be presented and verified. And in part of that negotiation, I think it's up for grabs whether we want to call this state historic preservation officer to testify, because I don't really understand the conditions, and I would like, to the extent that we can clarify it on paper, that's fine. But if we need to call this person and ask them what this is and what's meant by it and why it's being proposed. When we present conditions to the commission on a CPC application, we have a record that explains it. And there's usually a lot of banter back and forth about them, and a lot of wordsmithing about what they should be. So if this is an important issue, it needs to be treated, we need to pay attention to it. So So to the extent this can be done on paper, that's fine. To the extent we need to call someone and have cross-examination or live testimony on it, that's, you know, we can bridge that gap when we need to. But I guess I would, in terms of the EA, like I said before, I think the EA is going to be what the EA is, and if to whatever extent we need to supplement it, we'll have to do that. I don't think the EA really does more than describe staff's evaluation. So I think in terms of having that in the record, it's okay. I think testimony is, you know, the whole process of this whole process does involve critiquing the EA in testimony. And so this would be part of that process. But so I think that's what I'm going to go with at this point. I don't know how much time we would need to actually propose offer some sort of evidence on this matter. To be honest with you, I'll be out of the office for next week. So to the extent parties and staff can come to agreement on this, that would be great. If you need my assistance, it may take, you know, may push that process out a little longer. But so any questions about that?
Your Honor, I guess I just want to make sure I don't miss an opportunity here to
Yes,
cross-examine Mr. Kraft, and I'm a little unclear about sort of the parameters of that cross. If it's going to be it's going to remain in the EA, I want to be able to cross him about that, certainly.
Yeah, okay, so yes, and I didn't mean to I'm not I did interrupted your cross, but I'm not going to, you can still continue your cross. I just wanted to give you that that perspective, because if your questions are based on foundational, you know, whether and it relates to the motion, then you know that's already, I had enough information to come up with a decision on that. But yeah, you certainly can continue with your cross at this point. So.
Yeah, and I'm sorry, just to your previous question, would the briefing be pushed out accordingly? Is that the kind of the idea?
I think so, yes, that would probably make sense. So yeah, we would need to, I think we would just suspend those deadlines at this point and then figure out where they would land when the new process is put in place.
Yeah, I mean, I think the applicant certainly has an interest in moving this along as quickly as possible. So we're willing to work with the commission to accomplish whatever we need to accomplish here in short order.
Sure, I would expect that. So but so that was a good question about the briefs. I appreciate that. So yeah, so at this point, I think we'll just hold those deadlines in abeyance, and we'll have to come up, hopefully, to the extent it could be stipulated, new briefing schedule will be put in place based on that stipulation. You know, otherwise I can come up with a schedule once we have the rest of the process solidified.
Okay, thank you.
Okay, all right.
Did you want me to continue?
Yes, go ahead. Yeah, it's up to you.
Mr. Kraft, can we talk about the language in the EA related to the Peniel Chapel?
Yes.
So the EA states that there was an exchange with the State Historic Preservation Office, and that the SHPO response indicated the property would be negatively affected by the project, and proposed the two measures listed on page 32 of the EA. Did you author that portion of the EA?
Correct. Yeah. Yes. I put it in the EA if that's what you're asking.
I'm sorry, I didn't hear what you said.
I wrote that in the EA if that was the question.
Thank you.
And was it through the email in your Exhibit 1 that the SHPO indicated this in their response?
Yes.
Were you present for Ms. Nelson's testimony earlier today?
Yes.
Do you agree that the chapel is potentially eligible for NRHP listing based on National Register criteria for evaluation criterion A?
I believe so. I would trust mostly the field work and then SHPO's opinion. I'm reviewing the materials. I don't do the field work myself. So yeah, there's a certain extent I'm trusting their opinions.
So is it fair to say you haven't done an independent evaluation of the project's potential impacts on the Peniel Welsh Chapel?
Not outside of the application materials.
Meaning you reviewed the materials, correct?
Yes, and then I guess there's the historic preservation database, which we use, and I believe that was also part of the application. So there's a little bit more information in there sometimes.
So did you independently evaluate any or all of that information and come to a conclusion on the potential eligibility of the chapel?
I don't think that would be possible from just my own desktop review. You kind of have to do a field work for that. So no, I think.
So you cited statute 44.40 for the requirement to work with SHPO on this, correct?
Yes.
And 44.40 requires the agency, in this case, the commission, to determine that a proposed action will affect a historic property. Did you make that determination?
Yes, I looked at the application materials and it appeared that there would be visual effects to the property.
And when you submitted the form to SHPO as shown in Exhibit 1, is there a reason you did not provide your findings to the SHPO?
I think that was a mistake. I think it should have been checked that there would be adverse effects. However, I don't know that. I'm still, when I send that to SHPO, I'm still looking for their opinion on the matter.
So did you send that to SHPO looking for their opinion, or did you provide them an opinion? Did you provide them your opinion?
Both. Both. I did provide a little bit of an opinion that I thought that the view shed was had been affected by some modern construction in the area. You can see the type of farming is more of an industrial type of farming rather than what would have historically been there. There's a building nearby that may not have been historic, the roads, all of that. So that was my opinion.
So did you provide that opinion with this form in Exhibit 1?
Correct.
And was that in writing in your email to SHPO?
Yes.
You explained a little bit about your interpreted potential effect, but can you explain specifically which category of adverse effect you identified, and the adverse effects are defined in 44 44.31. Which of those categories you identified for SHPO?
I'm not looking at that statute right now. I can get to it. Which statute was it?
It's 44.31, the definition of adverse effects. And presumably you identified one of these.
Yes.
See which one it was.
That would be 1C, introduction of visual elements that are out of character with a property or alter its setting.
Do you agree that for eligibility for listing under criteria A, as we discussed earlier, that this adverse effect defined in 44.31 sub 1 sub C is not relevant?
You're saying A under 1, physical destruction.
So let me start over with that one. Do you agree with an evaluation under criteria A for listing? So outside of this, we talked about criteria A earlier.
Yes.
That the effect described in 44.31 sub 1 sub C is largely irrelevant to criteria A?
No. Let's see. So you're saying that it should be under criteria A?
Maybe I should break this down a little more.
I think if you just read the adverse effect you're directing him to, maybe that would clear up the question.
Well, I think part of the question is the criteria we're talking about. So there are certain, you agree, Mr. Kraft, there are certain criteria under which the buildings are eligible for listing, correct?
Yes. Yes.
And are you familiar with those criteria?
Yes.
And can you describe what criteria A represents?
That we're looking at right here?
No, criteria A for listing under the National Register.
Oh,
it's a criteria for evaluation for listing under the National Register. Do you know criteria?
Okay. There's one for the workmanship of the building. There's one for important events, important people, contribution to history. So I'm not sure which one of those are A without looking at the guidance. I know Ms. Nelson mentioned it earlier. If you could remind me, or I could look it up.
Sure, I'll represent to you that criteria A is connections to events important to the past.
Okay.
So the question is whether you agree that what's listed here as an adverse effect in 44.31 sub 1 sub C is irrelevant to a determination of listing under criteria A.
I'm not sure that there may be some circumstances where it could be a factor. A lot of this criteria is not just a black and white answer. It's can go over into multiple categories.
Do you agree that the visual effects of the project on the chapel do not impact the chapel's ability to convey its significance and historic use?
No, I don't think I would agree with that.
So then is it your position that the chapel, that criteria A incorporates strike that. Is it your position that the potential visual impact is an important metric in evaluating whether the chapel would be eligible for listing under the NRHP criteria?
Yes, it can be.
Do you believe that absent the two proposed conditions listed in the EA and in your testimony, the chapel would not be eligible for listing after the project is constructed?
If a vegetation buffer was present, that would reduce any of the visual adverse effects to the property.
I'm not sure you answered my question, Mr. Kraft. Is it your position that absent a vegetative buffer, the chapel would not be eligible for listing?
Well, there's really no way to tell that until it goes through the SHPO and National Register process. It's a nomination and there's a committee. They would decide all of those things. At that point, right now, we're basically just giving our opinions on what factors of this building we think are historic and what would be the impacts.
But you disagree with Ms. Nelson that the visual effects are largely irrelevant to listing under criterion A, correct?
I would say it depends.
Is it your opinion that absent the applicant providing resources to write the nomination for the chapel to be formally nominated for listing, absent that, the chapel would not be eligible for listing? I understand that's a convoluted question, so let me know if it doesn't make sense.
I think I know what you're talking about. That recommendation, from what I understand and how I've seen it used in the past, is more so meant to mitigate negative effects on a resource. It's kind of similar to, maybe we're familiar with the wetland bank. If you destroy wetlands in one place, you may pay money into the wetland bank to build it in another place. So in this case, if there was a negative effect on the property, this would try to create a positive effect.
So is it your position that there's still a negative effect on the property there's still a negative effect on the property if the first of your conditions is met?
I'm sorry, could you repeat that?
So assuming that the first of your conditions is met, which means that the applicant has entered a written agreement with the chapel, is it your position that there's the second condition is still required?
Well, the vegetative buffer would reduce the negative impacts. So I think there would still be negative impacts that could be mitigated.
Oh, sorry, go ahead.
There would still be negative impacts with the first one that could be mitigated by the second one.
But the impacts, you agree the impacts would be limited to impacts of the view from the chapel, correct?
The impacts from the project to the chapel are mostly visual. Yeah.
So the impacts to the chapel would be limited to view of the project from the chapel?
In most cases, yes, I think that's true.
Do you believe that the chapel is eligible for listing under any of the other criteria for listing in the National Register?
I'm sorry, for listing
on the National Register.
Thank you.
Yeah, I definitely take what the field work, I take the field work seriously, and that recommendation, it's work that I can't do. I can't do that kind of field work. I think the only way to know for sure what this property would qualify as or be eligible for and the criteria would be to go through the actual process and to work with SHPO. SHPO are the experts in the state on this topic.
So assuming though that you you were to undertake the sort of preliminary analysis that Ms. Nelson did, is it your position that the chapel would be potentially eligible under any of the other criteria?
I think I'm going to object there, Your Honor. I think it calls for speculation, slightly asked and answered.
Your Honor, we have to understand what analysis and what was reviewed here if this is going to be in the EA and we may not have an opportunity to cross-examine the SHPO expert.
Yeah, I'm going to allow it given the nature of this proceeding. So go ahead.
Would you please repeat the question?
We can have it read back.
Okay.
Yeah, thanks.
Questions? Excuse me. Question. So assuming though that you were to undertake the sort of preliminary analysis that Ms. Nelson did, is it your position that the chapel would be potentially eligible under any of the other criteria?
I'm not sure how I would come up. I'm not sure how I can answer that without doing the same kind of field work as her. As Ms. Nelson.
So are the recommendations that you provided in the EA based solely on what the SHPO provided you?
Yes.
You did not independently evaluate what conditions may be necessary or recommended?
The way that the process works is if there's identified a potential adverse effect, I go to SHPO, I do the 4440 process, and they come back with recommendations. I guess it's possible I may have different recommendations, but SHPO has experts in office, architectural historians. They do this stuff all the time. I think I usually agree with what they've said.
So the statute we discussed earlier, 4440 sub 1M, describes a.
I'm sorry, was that M or N?
1M.
Thank you. It's okay.
Explains that the state agency, in this case the PSC, shall identify the adverse effects on the historic property. And then it goes on, no, it's on the screen, excellent. It goes on to discuss the development of the proposed conditions. Is it your testimony that those proposed conditions were created entirely by SHPO without coordination with the PSC?
They came up with those recommendations, which is what the statute is meant to do. The end process is their recommendations. I have the right to I mean, I can talk to them about them and say, I don't think these are right, or there should be more. I think I've already given my testimony that I thought they were appropriate and standard.
Have you followed this process with prior solar projects?
In terms of doing a SHPO review, the 4440 process? Yes. Yes, I've done these reviews for other solar projects.
And you follow the same process every time?
Yes.
Mr. Crack, you agree that the project would not physically damage or alter the chapel, correct?
Yeah, I think that's true. Yeah, as far as what I know from the application materials, there weren't any proposals to move the chapel or anything like that.
I think that's it, Your Honor.
Okay. Yeah, I did have maybe a clarifying question. I think it was, and I thought it was stated in your testimony, witness craft, but I think the applicant attorney has just asked you questions about the statute, chapter 44, and sort of walked you through some of the process that's involved in the statutory obligations. But I remember reading that the process you're undertaking was based on an interagency agreement. Is my understanding correct?
So we have the 4440 statutes, which gives, that's the statutes version. And we do have a PSC SHPO programmatic agreement that it's kind of like our application filing requirements. It's more of the, a little bit more details. There's also a list of things that are excluded from the review that just wouldn't ever impact a historic property. So yes, there's one.
Okay. And does that agreement provide any guidance to the process in terms of putting a little more detail or meaning to the statute, that perhaps the questions that were restricted to the statutory process might not have covered?
Not sure.
So for example, you mentioned that your recommendation or your communication to SHPO was not necessarily, you didn't use the word an adverse determination that you gave them. It was more you're seeking advice from SHPO about the impact of the project on the property. Is that something that is allowed through the interagency agreement that doesn't seem to be, stated explicitly in the statute?
I'd have to look through the agreement and find that out. But that's typically what happens is if an adverse effect is identified on a historic property, then it's open for 4440. And that's what occurred in this project. I think I was maybe talking about other projects, or there are some instances where I may initiate the 4440 and they come back and say, no, there are no impacts. And that's, I think on the form there's a checkbox for that.
Yeah, because you kept using the language or the concept that you were seeking their advice, but you did make I just want to make sure that you did make a determination of adverse effect, and you were seeking, I think the way it's stated in the document, in the kind of the email that you received, that appears to be the official determination that it's a concurrence of SHPO, and it's just not here somehow. Hang on. It looked like the language that they were using, it was a concurrence of, and I'm assuming that means a concurrence of your prior determination of adverse effect. Is that how you would read that?
Yeah, I guess so. My initial evaluation of this, I think I said before, was that I thought the area had been a little bit modified anyways, so I wasn't quite sure whether or not this would adversely affect the property so much that it wouldn't be eligible for the register. And so I state that opinion in my email sending to them, and they came back saying that they disagree with me, saying that this would be. So in that sense, I'm saying that there would be an adverse effect when I trigger the 4440, but I can be unsure whether or not it would. Yeah.
Okay, I see what you're saying. Yeah. Okay. All right, great. Thanks. I just hope that helped me. So, okay. So we had cross from the applicant, cross from any interveners.
Yes, Your Honor.
Okay, go ahead, Michelle.
Excuse me, can we go off the record for a minute?
Oh yeah, sure. Go ahead.
My blood sugar's my blood sugar's low. I just need to grab something, or I'm gonna start losing it here.
Well, let's break. We'll take 10 minutes and we'll come back.
Okay, thank you.
So let's try to be back 2:55, please.
Mhm.
Hey, Debbie, feeling okay?
Yeah, I was starting to get feeling weird, so I
Yeah.
didn't want to get to that point.
Did you
I
get
just
a
have to.
notice or anything?
Yeah, I have my thing on here. It started
Yeah.
beeping. I don't know. You couldn't hear it, but
No. Just let me know if that happens. We'll take a break for sure.
okay. Thanks.
Shouldn't be too much longer, right, everybody?
Well, I know we were close to the end, and I was like,
Yeah.
okay, I can
No,
be fine.
it's-
I can be fine, and then it
No,
started
no.
beeping, and
That's no good. No, just let me know.
I've been trying to munch all day. So
So
Yeah, while we're off the record,
Yeah.
can I just ask, are you gonna issue a written decision at all on the motion?
I'm on a plane in like 4 hours, so.
Oh, good. But, okay, that's good to know. We'll try to figure it out with staff, the best.
Yeah, I think our best bet at this point is to work out a stipulation and yeah, to the extent you can't, I mean, I think I'll be back before before all the timing requirements end up before an order can be issued anyway, but yeah, I mean, just try to, and we got Zach there. So just try to make something that's sort of global. If you could have stipulation to the briefing schedule and documentation that's needed, and maybe more prep will work better. More work on the front end may be better for instead of trying to catch up with all the details at the back end. But yeah, so yeah, let's see what we can get. I'm hoping we can come up with just some documentation that'll clear this up for everyone.
Thank you.
Yeah. Okay, so we were at Ms. Association Representative Schultz, President Schultz, I think is really the terminology we need. And we're looking for witness Kraft. There you go.
Yes, sir.
There you go. So I don't, you need to talk a little bit. I think you'll, so make sure your connections.
My connection?
Yeah, okay, I hear you there.
Okay.
Not showing
I
up.
tried fixing the camera. It's working in the app, but not in this Zoom or whatever it is.
Very odd. Okay, so I think we're good. I think I did have, so remember you're still under oath. I did have just one brief follow-up question I thought about. And it's just, Witness Kraft, do you know if SHPO did any field survey on this property before it made its determination?
I don't know. The only thing I know is that Felipe told me he was going to talk with their architectural historian.
Okay, yeah, just curious about that. Okay. All right, so go ahead with your questions, President Schultz.
That sounds so odd, President. Thank you. Yes. Hello, Mr. Kraft. This is Carol Lee Schultz from Peniel Wells Chapel Association. I just have 2 quick points. Was there a review done with Bethesda Church? And if not, why not?
Yes, I believe the applicant mentioned, actually, I think that's the church. I think it's to the south. There's another historic property. If that's the one that you're referring to, I believe it was mentioned in the applicant's field work or the literature review, at least. Mm-hmm. So I was aware of it. It looked like, I'm just doing this from memory. So it looked like it was already surrounded by trees, mitigating the visual impact. And then I believe there were mostly alternative array sites there. So if the project was approved and panels moved to those alternative sites, and we think it would have an adverse effect, we would still be able to do that SHPO review.
I did not know if there was a historic review and helping them for their historical designation.
Miss Nelson did the field work, so you might have to ask her the status of all of that.
Okay.
I'm not quite sure.
Okay, my second point is, was there any historical, can't think of the word, have you checked out the history of the Native Americans in the area that had been there?
Well, In general, absolutely. Native American history is something that I've studied quite a bit. Specific to that area, what we would be looking for are recorded prehistoric Native sites, and there were none that were identified. That I'm just thinking from memory, but nothing was coming up.
Because this book, the history of the Oshkosh Welsh settlement has a.
I'm sorry, the history. You said the title, the history of
the Oshkosh Welsh settlement, 1847 to 1947. And it speaks of when the Welsh people came, they found.
Ms.
Indians.
Schultz, I'll just have to interrupt for a second.
Sure.
So are we asking a question of the witness or presenting new testimony?
I was wondering if he was familiar with reading that book. I was going to get to that question. If he was
Okay, well,
familiar
I
with
guess
that.
let's just ask him if he's familiar with the book.
Okay.
And we'll see if you can ask him a question about it.
And what was the book and the author, please?
The History of the Oshkosh Welsh Settlement, 1847 to 1947. Howell D. Davies is the author.
No, I'm not familiar with that book.
So that is the history, and I did not know if you were familiar with that.
Okay.
There is notations in there about the Native Americans.
Okay, we'll leave it at that because he hasn't referred to it yet.
That's all.
Anything else? That's it? Okay, thanks. Questions from other interveners? No? Okay. And redirect?
Yeah, really short, Your Honor.
Sure.
Mr. Kraft, you mentioned in answering some cross-examination questions that you have gone through this same SHPO process in prior dockets. Is that true?
Yes.
And in doing that prior process, did you follow the same procedures that you have in this docket?
Yes.
And in those prior dockets, did you also submit an exhibit in the style of the exhibit that you submitted to this docket?
Not necessarily. It's been kind of a running question of how do we get the 44.4 SHPO review into the record? And we don't have a clear answer for that yet. I hope we can find one. This was the solution this time. It seems like it wasn't perfect, but yeah.
Do you recall what prior procedures were in prior dockets?
In prior dockets, we've put that form and their response email on IRF. And that's it.
Okay, thank you. No further questions, Your Honor.
Okay, great. All right, thanks very much. You're excused.
Thank you.
So any other witnesses to take? We've gone through our list.
No,
All right. I'm sorry?
I said no, Your Honor. I believe that's it.
Okay, great. Thanks. All right. So with that, we have our evidence. We still have these pending exhibits that we've marked on the offered evidence list and it'll be marked on the transcript. So we have most of our post-hearing process in place, but like I said, we'll suspend the briefing schedule. And I think I've described what I was trying to lay out the parameters for how we can handle the SHPO issue here, and just look forward to seeing if we can get an agreement on entering some more information on that based on what we've learned today. So I think that's all we need to address. Any other questions we have? Party staff? No? Okay. Thanks very much. We're adjourned. Take care.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor. Have a great trip.
Thank you, Your Honor.